involving various stakeholders, including government departments, civil society organizations, academics, and experts in the field. It outlines strategies and interventions to prevent gender-based violence, support survivors, strengthen the criminal justice system response, and address the root cause of violence against women and girls. In March 2020, the Cabinet approved the National Strategic Plan on Gender-Based Violence, the establishment of the Interministerial Committee on Gender-Based Violence and Femicide, and the National Council on Gender-Based Violence and Femicide. Under Pillar 3 of the NSP GBV, the Department of Justice and the National Prosecuting Authority have been tasked with various responsibilities aimed at strengthening justice, safety, and protection for gender-based victims and survivors. The purpose of today's engagement is to see how far and assess the implementation of these requirements in terms of Pillar 3 and the progress that you have made thus far in fulfilling your obligation under this pillar. Thank you.
Thank you very much, Deputy Chairperson, Commissioner Subrayan Naidu. We will now move to calling upon the acting HOD, legal, Mr. Tsietsi Shuping, that will help us with section 12 of the legal processes. And if we may please, I know you like what I'm saying and you want to clap hands for me. I'm actually not asking for hands to be clapped. Yes, thank you very much. Mr. Shuping, if you may please come forward.
Thank you, Program Director. Good morning, Chairperson, Commissioners, and distinguished guests. Mine is to present in brief the mandate of the Commission for Gender Equality, as well as the legal process that Commission is engaging in. The Commission for Gender Equality is an independent statutory body established in terms of Chapter 9 of the Constitution of the Republic of South Africa. Section 181 provides that the Commission is a state institution with the purpose of strengthening constitutional democracy in the Republic. It is independent and only subject to the Constitution and the law. It must be impartial and must exercise its powers and performs its functions without fear, favor, or prejudice. The functions of the Commission for Gender Equality includes the function to promote respect for gender equality, protection and attainment of gender equality. We are further empowered by Section 11 of the Commission for Gender Equality Act, which provides the Commission has the authority to monitor and evaluate policies, practices among both public and private entities and all spheres of the society. Section 12 provides for the legal process. It states that the Commission may require any person by a notice in writing under the hand of the member of the Commission, addressed and delivered by a sheriff of the court, to appear before it at a time and place specified in such a notice, to produce to it a specific person, provided that such a notice shall contain reasons why such person's presence is required. The Commission may, through the member of the Commission, administer an oath from any person present at the proceedings, irrespective of whether the said paragraphs, whether indeed the person has been required under the said paragraph before it when conducting the oath or affirmation. Section 12, subsection 5 provides that a person questioned under subsection 4 shall be competent and compelled to answer all questions put to him or her in the matter connected with the investigations, shall be compelled to produce to the Commission any document or article in their possession that is necessary for the investigation. And by virtue of appearing before the Commission, they may be assisted by attorney or advocate or both. And in terms of Section 18, it provides for penalties on offenses It provides that a person who, without a just cause, refuses or fails to comply with the notice or refuses to take an oath or affirmation as requested by the Commission, refuses to answer questions put to them, refuses to furnish particulars requested after having been sworn in, gives false evidence before the Commission, knowing or falsely or not knowing or believing it to be true, willfully interrupts the proceedings at an investigation or misbehaves in a manner where the proceedings are held, defames the Commission or the member of the Commission in their capacity in connection with the investigation, does anything in which, where such investigation were proceeding in a court of law would have constituted contempt of court, that person shall be guilty of an offense and be liable to a conviction or a fine or imprisonment for a period not exceeding 6 months. Thank you, Program Director. That is the process and the mandate of the Commission for Gender Equality.
Thank you very much, Acting HOD. We are now going to call upon Nomthandazo Sithole, the legal officer for the province of KwaZulu-Natal, to come and present on the Department of Justice and Constitutional Development's response to the questionnaires that you had received.
She's going to fly. Good morning to my chairperson, deputy chair commissioners, colleagues, and my colleagues also from outside and our guests. Just a second, we are sorting out the presentation that side. The NSP was initiated after the 2018 Presidential Summit, as my colleagues have stated. This presentation focuses on the Department of Justice and Constitutional Development's response to the Commission's investigation into the implementation of Pillar 3 of the National Strategic Plan on GBVF in KwaZulu-Natal. It is in line with the Commission's role to monitor compliance or commitment or the implementation of the NSP, identify gaps affecting the achievement of gender equality and an effective response to GBVF. The Commission's Research and Monitoring Department procured a report titled Missing Pieces of the Puzzle, CGE Assessment of the Government's Implementation of NSP on GBVF between 2020 and 2022. The report tracked or assessed the implementation of the NSP as part of its broader studies to assess government programs and initiatives to combat GBVF in the country. For Pillar 3, the data obtained by the CGE shows that the DOJ and CD had finalized 50% of the development of solutions for online applications for protection orders. This enabled survivors of domestic violence to apply for protection orders remotely. At the time of which the research report was published, the assessment also highlighted that 104 police officials were trained for reactive interventions, which accounted for 18.4% of the 564 that were targeted for the 2020-2021 financial year. Furthermore, the data showed that the NPA had conducted sessions on social context awareness training for prosecutors and integrated stakeholders. In strengthening the criminal justice system, the data showed that by April 2022, 116 regional courts were upgraded to sexual offences courts. It further showed that DOJ and CD is also in the process of developing femicide watch initiatives. It is also worth noting that during the data collection process, there were 3 GBVF-related bills that were in a process of being finalized and have now been signed into law to strengthen South Africa's response to GBVF and to ensure that perpetrators are brought to justice. In conjunction with the CGE research report, the Center for the Study of Violence and Reconciliation also conducted a study using a scorecard on the localization of the NSP in 8 provinces. The data for the province of KZN was collected in 7 hotspot communities as identified by former Minister Bheki Cele. The Pillar 3 data shows that KZN fared best when it came to the presence of CPFs, moderate on community and SAPS response to GBVF. However, the province fared poorly on providing services to support victims of GBVF. The data shows that 36% of the complaints related to GBVF were effectively responded to within 7 days. 46% of the respondents said that there were no measures to strengthen victim and survivor-focused services. Furthermore, the study showed that 53% of the respondents said that there were no professionally trained GBVF case managers in their communities. The absence of case management is a cause for concern, with the implication that victims received professional psychosocial support. The DOJ, regarding sexual offences courts, in responding to the CGE's questionnaire, the DOJ reported that there is a total of 64 regional courts in KwaZulu-Natal that hear sexual offences matters. Further, there are 8 specialized sexual offences court. The specialized sexual offences court are set out here. 1,077 sexual offences cases were reported for the 2023-2024 fiscal year. You will see from the stats that Pietermaritzburg is leading, followed closely by Ntuzuma. For the first quarter of the current fiscal year, 222 cases relating to sexual offences were reported, as you can see on this presentation. However, there is a lack of information on case backlogs and average processing times, which makes it difficult to assess whether these cases are resolved without undue delays. Given the volume of cases in high-demand courts like Pietermaritzburg and Ntuzuma, the absence of backlog data raises concerns about processing efficiency. By not addressing backlog statistics, the DOJ and CD's response suggests that KZN experiences no significant delays, which does not align with the known challenges in the province. Further, the NSP GBVF monitoring and evaluation framework emphasizes the importance of strengthening capacity within the criminal justice system to address impunity and facilitate justice for GBV survivors. A key intervention under this framework is the clearance of case backlogs, with the South African Police Services as the lead implementing agency and DOJ playing a supporting role. For DOJ and CD to effectively fulfill its supporting mandate, it must demonstrate an in-depth understanding of its responsibilities, starting with the availability and analysis of critical data. Regarding the allocation of intermediaries to sexual offences courts, the DOJ submitted this data. You will see here that the total allocated to sexual offences courts is 12 intermediaries. Additionally, the DOJ and CD reported the presence of 33 intermediaries in KwaZulu-Natal. The CGE assumes that the 12 intermediaries allocated to the sexual offences courts here comes out of that figure of 33, which has been communicated to the CGE, with 14 ad hoc intermediaries for additional support. The intermediary staffing appears insufficient to effectively support the 64 regional courts and the 8 specialized courts, considering that 12 are already allocated to the specialized courts. The DOJ and CD's lack of transparency regarding caseload distribution, intermediary allocation to regional courts, and survivor access to support services prevents a thorough evaluation of its victim support efforts. This gap also raises concerns about the department's ability to provide timely and trauma-informed assistance to victims and/or survivors, potentially compromising the quality of support in GBV cases. Enhanced data collection and resource allocation, including resourcing of human capacity, are urgently needed to address these concerns and improve service delivery across KZN sexual offences and regional courts. Regarding victim support services and Tutuzela care centers, the DOJ and CD outlines its support for TCCs through participation in quarterly meetings with stakeholders where they discuss the operations and statistics on sexual offences and GBV cases. The response reveals that that the DOJ and CD largely assigns the management responsibility for TCCs and victim support services to the NPA and the SAPS, rather than detailing its direct contributions in line with its supporting mandates under Pillar 3. Regarding legislation and policy implementation, the department indicated that it regularly monitors and evaluates these legislative changes through quarterly provincial and national meetings to ensure compliance. However, the DOJ and CD did not provide specific reports or evaluations on the effectiveness of these amended laws in reducing GBV, and the Commission has not received these reports, even upon requests. This lack of reporting limits transparency and hinders assessment of whether the legislation has led to substantive improvements in GBV response. Secondly, from the response submitted, the DOJ's approach to aligning its GBV policies and practices with international standards appears limited and reliant on its National Office for Oversight. The response lacks specifics on how compliance with standards from bodies such as the United Nations is actively managed or evaluated, relying solely on the National Office for these alignments without further elaboration on its methodology or specific compliance checks raises concerns about the DOJ and CD's consistent adherence to international benchmarks across the province. The response also provides no information on any audits or evaluations that have been conducted to assess the compliance with these international standards, even though these evaluations are crucial for ensuring that DOJ and CD's practices meet global best practices for GBV response. This lack of documented audits or evaluations limits transparency and does not allow for a robust assessment of how well DOJ and CD's initiatives align with established standards, potentially leaving gaps in policy implementation and service quality. The DOJ and CD further indicated that it has implemented sexual offences courts and regulations under Section 55A of the Criminal Law, Sexual Offences and Related Matters Amendment Act, and that the Criminal and Related Matters Amendment Act imposes stricter bail conditions for alleged GBV offenders. These legislative amendments are vital steps forward towards improving survivor access to justice by ensuring that sexual offences cases are handled in specialized settings and that survivor safety is considered in bail hearings. However, the response does not provide data on the effectiveness of these measures, such as case processing times, the impact of stricter bail conditions, or the number of survivors who access these specialized services. The omission makes it rather difficult to assess whether the changes have genuinely improved equitable access to justice for GBV survivors, particularly for vulnerable and marginalized groups. The DOJ and CD highlights measures to address barriers, including geographic and linguistic challenges through courthouses in all KZN districts, interpreters and witness fees. The presence of courts across districts aims to reduce the travel burden on survivors, which is critical for accessibility, especially in rural areas. Additionally, the DOJ and CD submits that it has stationed interpreters and sign language interpreters in each court and provides intermediaries to assist vulnerable witnesses, sourcing additional resources from other provinces if necessary. While these measures are commendable, there is no data or analysis on whether they adequately meet the demand or on how effectively they serve the diverse linguistic needs across the province. The DOJ and CD's as indicated efforts to raise public awareness about GBV laws and justice services, which include ongoing community awareness campaigns, radio interviews, and the distribution of information materials in various districts, including rural and remote areas. However, the response does not provide metrics to gauge the impact or reach of these initiatives. Without data on the frequency of the campaigns, the number of people reached, or community feedback, it is rather difficult to assess the effectiveness of these public awareness efforts. On monitoring and evaluation, the DOJ indicated that there are quarterly meetings with relevant stakeholders which monitor the implementation of the Amendment Act, as well as monitor the National Register of Sex Offenders. I'm thinking that's what DOJ and CD meant there. Intersectoral meetings also are held to focus on addressing the challenges and finding solutions. National and provincial GBV committee quarterly meetings, which monitor and evaluate GBV initiatives across various levels of government, were also cited. However, there was no specific details on how these mechanisms impact the broader goals of Pillar 3. The DOJ and CD does not indicate how effective these discussions are in driving concrete changes or improvements in the implementation of GBV-related policies. In addition, there is no mention of how data from these meetings and the vetting process is analyzed or used to adapt strategies in real time. On resourcing, allocation, and budgeting, the DOJ and CD indicated that it allocates a specific portion of its budget to GBV-related initiatives, including funding for procurement of sexual offences systems for the courts and for outreach events. These allocations demonstrate the department's commitment to improving the judicial response to GBV by enhancing the court's technological capacity and engaging in public awareness campaigns. It does not provide specific details on how the funds are distributed among different programs or the criteria used for this allocation. The lack of clarity makes it difficult to understand how the department prioritizes its resources or whether certain programs are more adequately funded compared to others. Additional information on the allocation process would offer insights into how the DOJ and CD ensures that funds are used efficiently and aligned with its strategic priorities. On challenges faced in the allocation of resources, the DOJ reported that one of the primary challenges is budget constraints related to upgrading courts to comply with the regulations for sexual offences courts and ensuring that privacy for survivors of domestic violence seeking protection orders. The lack of sufficient space in courts to accommodate necessary upgrades poses a further challenge. This suggests that there's an ongoing struggle to meet physical and special needs required to properly support survivors of GBV. While the use of park homes has been considered as a solution, the use of temporary structures does not or may not address the underlying issue of inadequate infrastructure, and the department may need to explore more permanent solutions to ensure that courts can meet privacy and safety needs of survivors. On financial accountability, the DOJ and CD indicated that funds are allocated to GBV initiatives and are monitored through reports from the Finance Department to the CFO. However, the response does not provide specific information on how often these financial reports are produced or whether they are subject to further oversight or review by external auditors or other external bodies. A clearer description of the financial oversight mechanisms in place would aid and would provide greater confidence in the department's ability to manage its resources effectively. The Commission has also requested information on audits or financial reviews conducted in the past 2 financial years, but no specific details have been provided by the DOJ and CD. Without this information, it is difficult to fully gauge the department's financial accountability and its commitment to maintaining transparency in its budgeting processes in the province of KZN. Regarding the safety of the victims and or survivors of GBV, the DOJ and CD has indicated that it has established security measures at all courts to protect victims and survivors of GBV. Courts are equipped with security personnel who conduct searches of individuals entering premises, ensuring that no weapons or dangerous items are brought into courtrooms. Additionally, the courts are designated as gun-free zones. In the event of an incident of violence or threats against victims or survivors at the courts, the DOJ and CD indicated that the contact details of the court managers are displayed in all courts as part of the procedure to address such situations. No information was advanced regarding the training of staff, including the same court managers, to respond to such incidents. Training is a critical aspect of ensuring that court staff can effectively manage potentially dangerous situations. Without information on the specific training in place, it is difficult to assess the department's readiness to handle incidents of violence or threats at the courts after a victim and a survivor has contacted the court manager. Regarding accountability and oversight, the DOJ and CD reported that their internal auditors will evaluate the performance, information, and assess compliance with relevant prescripts. As mentioned above, and they also mentioned that non-government organizations and Chapter 9s are also part of intersectoral committees to maintain accountability. A system for GBV survivors and public to lodge complaints or provide feedback on its services, which comprise of displaying contact details for the provincial head, director legal, and director court operations, which are shared at all the courts. On complaints handling, the DOJ and CD submitted a complaints register which revealed the following. Complaints regarding maintenance have remained consistent over the past 3 years. There is no information provided on how these complaints were resolved or the turnaround time for resolving them. This lack of resolution information is a concern for the CGE, considering that economic or financial abuse is recognized as a form of domestic violence and a contributing factor to gender-based violence. Furthermore, the DOJ and CD submitted attendance registers to the Commission from trainings held on the Domestic Violence Act, but the high number of complaints on the handling, particularly, of maintenance matters does not reflect an understanding of the DVA. It is crucial that these cases are prioritized and finalized without undue delays. In conclusion, while the DOJ and CD has made notable contributions towards the fight against GBVF, significant gaps in data reporting and transparency, hinder the Commission's ability to effectively monitor DOJ and CD's implementation of Pillar 3 of the NSP GBVF. Addressing the gaps raised by the Commission is essential in ensuring that the department's efforts lead to meaningful, sustainable change in the fight against gender-based violence and femicide in the province of KwaZulu-Natal. Thank you.
Thank you very much, Nomthandazo, Legal Officer from the Office of the KwaZulu-Natal. I am now going to ask the Acting HOD to come and help us with the oath administration. While that is happening, let me then ask DOJ to please come and sit in this front seat so that we can then have the provincial head, Ms. Pat Moodley, to take us through their presentation. Please. DOJ had also submitted a memoristic. I am asking for assistance that we have that presented when they need it.
Thank you, Program Director. May I ask the accounting officer to join me on the podium for the oath, please? Thank you. Ms. Moodley? Oh, yes, here. Thank you. Thank you. This is just for the purpose of administering the oath of affirmation. Yes. Thank you. Would you like to take an oath or affirmation?
Oath.
Oath, thank you. Yes, okay, maybe if you can
Oath.
close on the side. Oh, thank you, Chair. All right. Yes. All right, thank you, yes. So you said it's an oath that you will be
Yes.
taking. Thank you. Can you please repeat your name for the record, please?
Padmavati Moodley.
Yes, please repeat after me and say I, her name and surname.
I, Padmavati Moodley,
Do hereby make oath and state.
do hereby make oath and state
I know and understand the contents of the declaration I'm about to deliver.
I know and understand the contents of the declaration I am about to deliver.
I have no objection to taking the prescribed oath.
I have no objection to taking the prescribed oath.
I consider the prescribed oath to be binding on my conscience.
I consider the prescribed oath to be binding on my conscience.
Please raise your right hand and say, I swear that the contents of this declaration
I swear that the contents of this declaration
are true,
are true,
so help me God.
so help me God.
Thank you. The deponent is duly sworn in, Chairperson. Thank you. And then you will proceed then. Thanks.
Thank you very much. And we can then proceed and invite DOJ to please present their report. Yes.
Good morning, Commissioners. Good morning, DPP and colleagues who are here today. So the last, let me first of all say that I'm over 60 years of age, and I received a subpoena. I was served with a subpoena by the sheriff of court for the first time in my life.
That's how effective we are. We go even for over 60.
I can see that. So I was a little bit taken aback by it, but because we have always responded to any kind of request by the Commission. We have had many meetings with the Commission in KZN, We take the work of the Commission very, very seriously, and we understand our obligations to report to you as the Commission on Gender Equality. But I just thought I needed to start off by saying that. Yeah, the subpoena, it was quite something.
Are you saying maybe that was an unnecessary step at this stage based on the relationship or what? Because this is feedback.
Oh, yeah. I think maybe particularly in respect of my office, and I think that the knowledge that the KZN Commission, the Office of the Commission, the Director here, has with us, it might have been an unnecessary step, and maybe a cost-saving step as well, because we would have responded. Okay. No, thank you. Thank you, Chairperson. So, Commissioner, there were lots of issues that were raised in the presentation that was just made. I would really like for that presentation to please be shared with us so that we may interrogate the presentation much more closely and respond accordingly. I do want to say, just for a clearer understanding, that we are a national entity, the Department of Justice. So our obligations in the region are to implement the legislation, to implement policies of the department, which are developed at national level. We make input when we are consulted, but we are not we're not responsible for instance, one of the points that was raised is that we were unable to comment in respect of how we adhere to international obligations on GBV. We don't do that. The national department develops policies like they did with the NSP. And those policies, when they're developing those policies, they take into account what our international obligations are. So we then don't go back to the international charters, and the international conventions and that kind of thing directly. We then follow the policies that have been developed by National Office, and we implement those policies. So, there isn't an obligation on us in the province to go back to international instruments and say, oh, are we meeting these targets and are we doing that? Because it's already incorporated, it's domesticated when our national policies and legislation is drafted and developed. So that's the one thing. But there were lots of things that I would really like an opportunity to engage on more fully. I do want to say at the outset as well that I'm very glad that the NPA is here with us today, because in our obligation on Pillar 3, on the NSP, we work very closely together. We are totally reliant on each other for the support in making this, this function, for us to realize our function in implementation of the NSP in the region. There are provincial committees that are chaired by the Department of Justice, and we will speak to some of those. They're intersectoral committees. So they are the committees that are actually monitoring the implementation of the NSP. We will speak to that, and I'm sure that the NPA will speak to those as well. As a disclaimer at the beginning, I want to please ask the commissioners to ignore the statistics that the DOJ has presented. NPA has got the statistics for this part of our work, and they will present those statistics. The reason I say that is that we rely on a system called the ICMS system, and if you haven't heard from National yet or from the other provinces that you have visited, that system has been plagued with challenges. Yeah.
So that we understand.
Yeah.
Are you already in the
No,
report?
no.
Oh, okay.
No, this is my introductory remarks. Sorry. We're going to go into the presentation. Yeah. Yeah. So, just to say that to you as, a disclaimer on the stats, so we don't go into the stats now, and I would rather for the DPP and her team to speak to the stats, the issues on backlogs, and the fact that together with us, we are the main stakeholders, but the other critical role player is the judiciary in managing the caseload, in managing the cases that come to court, in ensuring that there are no delays. Because actually it's the judicial officer who is the head of court, who dictates the way that case unfolds, dictates whether I'm granting another postponement in this matter or I'm not granting another postponement in this matter. You've changed your attorneys 3 times already. So you know what, I know you're using this as a delaying tactic, so I'm not postponing this matter again. It's not our call, it's not the call of the NPA. So I just wanted to, to make those points up front. And yeah, maybe the question and answer session should actually come after both presentations because all our work is linked, but that's just a suggestion from my side. I'm going to hand over to Ms. Asya Khan. Ms. Khan is the Director Legal in the Department of Justice, and as such, she is literally the owner of the implementation of the NSP in the province and has been working for the last 2 years on it. Thank you.
As I sit here.
I wanted to hear from the chairperson and also from the media team.
Yeah.
Preferably if we make this step.
Let's go with it. Yeah, you know what?
Yeah.
It's purely for recording purposes. Yeah. So it may be inconvenient to you, but
No,
if you could
no,
bear
not
with
at all.
us. Thank you.
Everyone laughs, but I write a lot, so you can see how much I'm going to. Thank you, Chairperson, and thank you to all for allowing us this opportunity. I just want to say, Chair, that when drafting our presentation, we took into account our responsibilities in terms of the NSP Pillar 3. That is a national document, and as rightfully said by my colleague Mtando, that it's made up of various role players. So when I responded, when we as Justice responded, we picked up our responsibilities in terms of the NSP and how we are implementing it in KZN. So I just wanted to clarify that. So my colleague mentioned our intersectoral committees that we chair, and I just wanted to say that lots of these committees that we chair are because of you'll find it in the legislation. The DG of the Department of Justice is responsible for coordination of various pieces of legislation. You'll find it in the Trafficking in Persons Act, you'll find it in the Sexual Offences Act, where it's the DG of Justice that coordinates. So at a national level, we have these structures and we replicate them in the province, and it's the Department of Justice that chairs them. So just for clarity, Chair, I wanted to let you know who sits on these fora that we chair, and you'll notice that it's actually all-encompassing of government departments, civil society, Chapter 9s across the board. So I wanted to give you an indication that we have these meetings on a quarterly basis, and I indicated here the dates that we had the meetings. We chair the Provincial Domestic Violence meeting. We don't have a Pillar 3 committee because in KZN we have various structures that talk to our obligations in terms of Pillar 3. So the Provincial Domestic Violence and Femicide Committee is one of them. The Provincial Sexual Offences Committee is another one where we discuss matters relating to sexual offences. Then we also co-chair the Provincial SOGI's task team, which is Sexual Orientation and Gender Identity Expression. And we co-chair the Provincial, the Rapid Response Task Team for this committee, which deals with case management, where we analyze the cases and we talk about what are the delays by our stakeholders.
Then we chair the Provincial Trafficking in Persons meeting, Chair. You'll notice we have one meeting per quarter. And with the Trafficking in Persons, I also chair the Rapid Response Task Team meeting, where we talk about our case management, and it's a smaller, in-depth, more concentrated meeting where there's very few of us, where we talk about our case management and the challenges why our case is not moving. The NPA is a very, very critical stakeholder for us in all these task teams. And then, Chair, we did share with, as my colleague confirmed, we shared some registers where we do training. And I want the Commission to understand and share that we do a lot of ad hoc trainings as well. So we might get a call from a particular district where our managers are requesting training on a certain piece of legislation or on a tool, because we have our key performance indicators that we monitor. So we do a lot of ad hoc trainings. But in terms of the Pillar 3, they're very big on debriefing, if a chair has looked at their document. And we've successfully held debriefings across the various financial years. And for this financial year, on the 5th and 6th, we've got a specific debriefing session for our intermediaries and domestic violence clerks, because we appreciate the work that they do and the fact that they really need to talk about these experiences that they are going through. Chair, we did a whole lot of training for domestic violence clerks in KZN from the 16th to the 20th, where we covered our key performance indicator training. That is, how do we monitor and capture accurate data? But as Ms. Moodley has said, we have been plagued with issues in terms of our systems. And when we did that training, we did a training on the legislation and the amendment to the Domestic Violence Act, and what are their roles and responsibilities to ensure effective implementation. And then, Chair, we have 33 intermediaries in KZN, and the one of the 12 is where we concentrated on our pure sexual offences courts, just for the Chair and the Commission to understand what facility, what resources we have pumped into those courts. But when I've elaborated in this presentation, and Chair, I've given Zanele a hard copy of this, should Chair wish to retrieve it, where we covered exactly how many intermediaries we have in each district and per court. So this is how our 33 are made up at the moment. Chair, I think Chair appreciates that we have not done recruitment in the last 2 years because of the moratorium, and we've just started to advertise, I think, a few months ago. So hopefully we'll be recruiting in those areas where we lacked capacity. Chair, I want to take you, sorry, I think I'm moving all wrong. My apologies. Yes. Okay. Yeah, sorry. Technology and I. Mm-hmm. Then I want to say, Chair, we've appointed, my apologies, that was my typo, 13 ad hoc intermediaries. And this is to accommodate the amendment to the legislation, where the intermediary services goes beyond that of a child or a person with mental disabilities testifying in a sexual offences matter. The legislation now allows any vulnerable person to make an application to court for the use of an intermediary. And because our database was not sufficient to accommodate these changes, we've appointed ad hoc intermediaries who've gone through the entire training process, and we're very fortunate that our intermediaries, ad hocs, have been trained by Justice College. They were one of the few lot that did get training. So we do have a database. Unfortunately, Chair, we couldn't appoint as many as we'd like to. It's just that the influx of CVs was not that great, but we have undertaken to continue to advertise for these ad hoc intermediary posts, and we, in our intersectoral committees, we share it with all our stakeholders, Department of Social Development, Department of Education, to say if they know of any retired teachers and social workers who'd like to form part of our ad hoc intermediary database, to please ask them to send us their CV. So it's a continuous recruitment process. Then, Chair, my apologies that it's 64, it's 73 regional courts in KZN, and the 12 that we have, the 8 that we have identified here, these are the 8 courts that were upgraded to meet every requirement of a sexual offences court. I see Deputy Chair is counting, so I want to take her back. There's 3 on this page, and there's the balance here. So, Chair, these are courts that tick the box. When we commenced with the upgrading of sexual offences courts, it was in terms of the Matso model. And there were certain criteria that had to be met. So these courts meet all those criteria in terms of having a separate child waiting room, intermediary facility, separate waiting room for the family, separate restrooms for the children, so the child doesn't have to walk and use those that are used by the public, an intermediary, a court preparation officer, a sexual offences system. So these 8 courts ticked the box, and these were the courts that we originally identified for designation as sexual offences courts in KZN. And then, Chair, we're talking about procurement and upgrading of systems. All our sexual offences courts have sexual offences systems where the victim or the child testifies through an intermediary in a separate room. Now, we do know that some of our systems are old, and they've CGE, I know Zanele quite often contacts me. She's at a court or she's got a complaint that the system is not functioning. And unfortunately, each system is quite expensive. It's between 250,000 to 300,000. And so we, from our KZN budget, the provincial head allocated 1 million rand from our budget for upgrading of the SOS machines in certain courts. And so we had identified the first 6 courts that desperately needed new machines. And then we received 750,000 rand CARA funding from National Office. And we then identified an additional 9. So in KZN, we are procuring 9 new SOS machines to replace the old ones that are not functioning very well and effectively in these courts. And I want to say to the chair, because it's over a million rand, we've had to go through the tender process. So the bid specification committee has sat, I chaired that committee, and we're finalizing that process for it to go to the next process in terms of tender. Then, Chair, the National Register for Sex Offenders, my colleague spoke about the fact that we're doing vetting. What I want to say is that when the amendment to the legislation happened, the vetting function was decentralized to the provinces. So anyone who wants to work with a child or a vulnerable person needs to be vetted against the National Register for Sex Offenders. So now that it's being decentralized to the provinces, I am the provincial registrar. Between myself and Mrs. Twala, my senior legal admin officer, we do the final approval on these vetting applications. So for this financial year, we issued a total of 2,000, up until I've submitted the report, we issued a total of 2,887 vetting certificates. And I want to say, Chair, that we are inundated. It's not only, it's a function that we are performing amongst all our other functions. So we receive applications from every government department, from every civil society person, from persons on the street. So it's a lot of work. It's a three-tier process, and the final approval lies with myself and Mrs. Twala. And we really, for last financial year, it was 2,887, and up until end of October for this year, we've done 2,906. We're under a lot of pressure from departments to fast track their applications. Chair, I want to give you our commitment that we're trying the best that we can with the limited resources that we have. Directorate Legal attends to all pieces of legislation, implementing the Pillar 3 as well. Then, Chair, part of the Pillar 3 talks about the victim-friendly courts. It's one of our obligations to ensure that our courts are victim-friendly. Chair, through the various financial years, we have been doing this as a continuous project, and these are the 9 courts that we identified for this financial year. And I just wanted to say to Chair that when we identify these courts, this is what we do. Basically, the court needs to have a ramp or access for someone. It needs to have, if it's more than 1 floors, it should have a lift or a ramp going between floors. We should have a place for guide dogs where they can be seated. And we have to appoint a person called the Reasonable Accommodation Coordinator at each of these courts. It's an identified official who's been trained. So, and their name is displayed so that when a person with a disability comes to our court, they're not walking around without any direction. They are directed to the person who will then guide them through the process and show them where they can go, where they can sit, and stuff like that. So there's signage in the courts. We have reasonable accommodation signage. We have, these courts have braille material so that if it's required, and we've also accommodated for guide dogs where we've provided water bowls, dog mats, etc., so that they can sit next to the person that they are guiding. Chair, these are just dates of when we did training for our officials to equip them to manage their functions. And then, Chair, outreach events and public awareness. We did send in some attendance registers. If I sent all, I think it would have been a very, very massive file. But what I wanted to say, Chair, in terms of this, we have been allocated a budget of 100,000 Rand for this financial year to conduct outreach events. I'm not going to say more about this because I'd like the provincial head to talk about it after I am done. But I just touched on, and I just gave Chair and the Commission an indication of the events that we've hosted and participated in from April up until end of September. And Chair, I want to say that as Justice, unfortunately, we don't always host these events, but we are a very proactive participant in the province with all outreach events and public awareness sessions that are taking place. Chair, I think I've covered on some of the responses and a more in-depth presentation, but we are open to any questions. Thank you.
Thank you, Ms. Khan. I'd like to, I'm not sure if Ms. Moodley would like to add.
Yes.
Ms. Moodley.
Yes, can I just please add before we hand over to you for
Do you mind?
question?
We'll order the podium especially for you. Don't do this to us.
Chair, I just wanted to add that in respect of those sexual offences systems that we had, Ms. Khan said that they were very old, and we're in the process now of purchasing another 9, I think it is, for our region. This financial year, that tender is out. What I do want to say is that we do have an alternate method. So where the sexual offences machines are not working, we have devised a system where the evidence of the child from the testifying room can be taken via Teams. It's as simple as that. Every magistrate in this province has a laptop. Every magistrate in this province has data. Every court manager has a laptop. And the NPA, the DPP has supported this initiative so that, prosecutors have to buy in. It's not going to be an objection from a prosecutor that's going to prevent this from happening. So that's our alternative, just so that when a matter involving a child victim is before court, that matter is not postponed because the SOS machine is not working. There is an alternative. Then in addition to that, every single courthouse in KZN has a virtual platform. So we have a platform where we can hear with vulnerable witnesses, and we have done it in sexual offense matters. I think it was Verulam. There was a sexual offense matter where a child was visiting South Africa and was a victim of a rape. The child had to go back home to India. And the child and the mother would otherwise have had to be flown in from India to South Africa for that child to testify. That didn't need to happen because we connected virtually and the evidence of that child was heard remotely, So the provision is in the legislation, and we just want to show that we are implementing it. That's not the only case. There are many cases where that happens. And then, Chairperson, I want to invite you to go visit the court at Point. Because in that court, every single courtroom is a virtual platform. Any domestic violence matter, sexual offences matters are not heard there, of course, but because it's a family court. But any domestic violence matter, any maintenance matter, the one other thing we found was that very often maintenance matters, the respondent has gone away, somewhere else in the world, he's somewhere else in another province, that kind of thing. And when we need to bring them to court, then we would have had to fit the bill to fly them here and accommodate them while they're here and that kind of thing. And we noticed that our witness fees were just increasing, and they're really exorbitant. So these are all measures also to bring that down. But it really helps the process of these matters through courts. So we're using it in maintenance, we're using it for domestic violence, the virtual platforms, that is. And and we've provided the judiciary with the tools of trade. So I just wanted to make that point. And then, Commissioner, there's one other thing I want to talk about before I close. I'm coming to the end of my career. I'm retiring very soon. And I just want to I'm a child's rights activist. So I just want to make this point that we all concentrate on gender-based violence and we exclude children. You would have seen in the media recently there was a lot of debate about why the NSP itself excludes children. There's no mention of what we're doing with children. So, for the room here today, we all know what GBV is. Do we now know what VAC is? Okay? We all know what femicide is. Do we know what filicide is? Okay, so we need to ask ourselves these things going forward. And I just want to say that the Children's Act, for instance, makes mandatory reporting of all abuse against children, whether it's sexual abuse or physical abuse. But there's not enough monitoring and evaluation of non-compliance by the different stakeholders in respect of that. We're not reporting, and nobody's challenging those people who are not reporting. So all health professionals are supposed to report. all DOE educators and people who work in that system are supposed to report. SAPS is supposed to report. But what are we doing with that? So, and then of course linked with this is the whole aspect of teenage pregnancy and how are we managing those cases? And you know, the cases that we know about are the cases where children are in school. But even those cases where children are in school, how are we following up on them? Omashni is here and the DPP, and you know, we tried to set up this committee a couple of 18 months ago, I think now, where we wanted to follow and track these cases, you know. And unfortunately, stakeholders have not been very forthcoming in respect of this. But I've just heard from Ms. Naidu now that on the 28th and 29th of November, the Office of the Premier is, and UKZN is hosting a conference on teenage pregnancies. So it's really, I mean, my diary is fully booked, but I'm going to steal some time to go there to figure out what is happening in respect of children in KZN. So I want to say that, you know, really what we need is we need some kind of clearinghouse. So every matter involving a child needs to come into a platform, and it can be, you know, it can be run by the provincial commissioner of police, it can be run by DOJ, whoever, but every matter involving a child needs to come into a clearinghouse where we know that this matter has come in. It has come in from Ndwedwe, and this is what has happened to this child in Ndwedwe. It comes in from Ntuzuma. This child is pregnant and this child is in school. What is happening with those matters? And we need to commit as the leaders, you know, of the various JCPS cluster departments, that we track these cases and that there is an outcome. So that's my plea. Thank you, Chair.
Thank you, DOJ, for the comprehensive presentation. And I've been given a direction as to the request of whether we're taking NPA first and then questions later. The chairperson and her commissioners have taken a resolution that let us stick to the program as is. Thank you. And now I'd like to hand over back to the chairperson to take us through the questions and responses process.
Should be giving feedback. I actually think you raised very critical points, and I would like, as part of your leave behind, as part of your legacy, to be the last part that you have mentioned, so that the person who takes the baton from you actually runs with those. Those are very, very good suggestions. In relation to the same suggestions, if all of you can familiarize yourselves, please, with the work of the CGE. We are doing a lot of work on teenage pregnancy. We had one of our commissioners, may her soul rest in peace, Commissioner Ntulitlo Obatla in KwaZulu, Mpumalanga, working on filicide. Unfortunately, it sort of lulled after she passed on. Last year, yesterday, 19th of November 2023, and you know, because of change of guard and all of that, that is why it had that lull. But we totally agree with you. Those are the areas that we want to go to as the CGE. All right. Let me start off by saying, in terms of the issue of subpoena, I hear you. But I just want to explain to everyone, this is a legal and legislative process. It is captured in section 12(4)(b) of the CGE Act. I would like you all to familiarize yourself with the CGE Act, please, so that when we call you or whatever, then you know what's happening. Section 12(4)(b) of the CGE Act says we need to subpoena because this is a legislative process. We do not want to write you a love letter, and when you don't pitch, then we invoke legislative processes, when in the first place it was just a love letter. It needs to be clear that this is a subpoena, and that subpoena says if you don't come, there are repercussions. But it also, as we all know, if you come, you are expected to testify and to provide certain information. That is the purpose of a subpoena. So from the onset, we lay the foundation of a legislative process. So that is where we're coming from. But we still remain friends. Zanele still loves you. But I just wanted to explain that. And I know a lot of people, even the oath, say, do I have to take an oath? Yes. Because when you are there, you are not there as Pat Moodley, you are there as a duty bearer. And all of this information, when we go back and verify, we will be holding you accountable in your professional capacity, so that tomorrow when you are retired, you don't have to worry about the CGE coming for you. We will go for the portfolio of the person who takes over from you. Thank you. That's the one I wanted to explain. But with regards to, to international obligations, we ask this because South Africa was very big in 1994 on ratifying certain of the international instruments. Some have worked for us, some have not. But why some have worked and others have not worked is because we tend to get lost in where we fit in the scheme of things. Whereas domesticating is saying it's coming from the top down, but down up in terms of reporting. So at all times, when we are fighting GBV, we need to know that we are transgressing CEDAW if we are a capital of rape, if it is a fact. Where a child from India gets raped and has to go back home, we need to know that over and above domestic legislation, we've got that international obligation to give them a right of reply. And that is why at all times we need to say, how far are you with all those instruments that we have ratified? Just to wrap this up, I want to give an example. We as the CGE are in the process of working with Caster Semenya to look at the DSD case that she is facing. And the country was found wanting because international athletics, world athletics, said, no, Caster, you cannot run by virtue of certain things. Those are the measures that, according to section 9.3, 9.4, 10, and 11, we do not find offensive in any way. In fact, 9.4 says, should you discriminate unfairly based on these things, should you discriminate, therefore you are discriminating unfairly. But now everybody is running helter-skelter because we have signed onto an international body of which we are a member. So it's bigger than we realize. You know, and the question then becomes, who trumps who? Which instrument trumps which one? And what do we say to government? What advice do we give to government in terms of moving forward? And that is why at all times we keep asking that question. Yeah. So I just wanted to clarify those two, and then to also commend the DOJ. There's a lot that you are doing. I don't want you to take it for granted. To have vetted 2,997 in the 1 year, and the following year it even increases to 2,906 is no mean feat. Some provinces, their registers lie dormant, gathering dust. You are doing something right there. For you to take your intermediaries, limited as they are, for training at the Justice College is a masterstroke. I wish you could work with traditional leaders in terms of the traditional courts and work with them in terms of the administrators and the support staff inside the traditional courts, so that they appreciate confidentiality, they appreciate minute taking, they appreciate record keeping, they appreciate proper use of language in interpretation. You know, so all of those things. You are trailblazing in so many ways that you may not be aware, and I actually felt I need to mention here. Now, we're going to get to the not so unpleasant part, but I'll leave it to my commissioners, and then afterwards, the team will ask. But so far, well done, and keep it up. Thanks. I'll hand over to the chair, and then you can give to Komgomani, and then Naidu, and then we'll go to staff.
I'm the DC, not the chair.
Oh, sorry.
Thank you, Chair. Thank you, Ms. Mudley. Thank you, Ms. Khan. Chair, I think I need to put in a disclaimer. Ms. Khan and I go way back, so if I call her Asia, please forgive me. Okay. As Chair pointed out, many congratulations. You are doing fabulous work. I'm very, very impressed to hear about the virtual courts. I'd like to hear how you manage the international interview with testimony. You see, I haven't been in a courtroom in a long time. The testimony of the witness and time difference, etc. But fabulous, very, very impressed with that news. I have lots of questions which may overlap with the questions I have for the NPA. So I'm just going to stick to the issue of vetting and maintenance for now, and the National Register for Sexual Offenders. Congratulations there again. However, we still need to do more. And what will be required of the department, or what will be required? What do you require in order to ensure that we get those names on that register as soon as possible? Because there is, as much as you have achieved, as much as you have, there is need for more names to get onto that register as soon as possible. And then maybe this, like I say, it could go two ways. The issue of maintenance. Financial abuse is legislated. It's a form of domestic violence. We now have legislation that provides that when you get an assault victim that comes through to the criminal court, there's a right placed on the magistrate to issue an interim protection order. Do we have, or is there something in place where we can say this file needs to now go to the maintenance court and places an obligation on the maintenance court to deal with it? And is it in practice here in the province? I'm asking this question because it's very difficult to see it in practice outside in the other provinces. And I speak where a year ago I was still a part-time commissioner and I was a practicing attorney. A year ago it wasn't in place. So I'm asking this question from that perspective. Is there something in place to say a file needs to be opened in maintenance court, we're going to deal with this matter there and there from, let's just say, criminal court phase when that person enters the criminal court? Like we have with the interim protection order that's issued by a magistrate in the criminal court, that file is then transferred and it's dealt with in the domestic violence court, okay? That is my question to you. I think the rest of my question is going to overlap with the NPA, so I'm going to hold on to that questions for now. But if it's something that you can answer at a later stage, please assist. Thank you very much.
Thank you, Chairperson and Deputy Chairperson. Good morning, Ms. Modley, Ms. Khan, and everyone in the room. As indicated, I'm Commissioner Bongani Ngomani. I'm going to ask questions that by and large were not covered by your presentations. Therefore, I request that if you are not able to answer, you will say so, then you can submit in writing later. I hope that is in order, Chair. Yes, so that you don't try your luck and end up giving maybe inaccurate information. Firstly, it's in respect of how do you handle and what is the prevalence of false sexual offences case in the province so far? Do you have them, and how prevalent are they, and how do you handle them? And also, what is the follow-up method on cases withdrawn by the court on technicalities or under the notion of further investigations? You'll realize that I'm maybe the only one who's not a lawyer here, so I'm not using your jargon. Or under the auspices of further investigations, how do you handle that? What are the follow-up methods there? Because you will find people saying my case is under further investigation, and it's 3 years now, it's 5 years, no one is updating me. But that particular victim still hopes that something will happen because the matter is under further investigations. I think the chair of the commission has reflected on this matter. I wanted to check your relationship with the customary courts and how do you capacitate them. It came from the chair, I'm just emphasizing it. Then the issue of witness protection system, I'm not sure whether it's yourselves or it's NPA that is handling it, but I just also want to check how do you manage it and how effective it is if your public is fully aware of that, because other people, they may witness a crime, a GPVF crime, and they may not find it easy to come forward because they fear for their lives or they are being intimidated. So it will be good to know if you've got a special witness protection for GPVF matters or not. I'm about to finish. You reflected on the issue of children cases, but also if you may reflect on the disability and older persons cases, because at some stage there was serious sexual abuse of older persons, and we know that disabled people are also serious victims, but they don't have much voice. The last one, it's your relationship with civil society in respect of your advocacy and awareness against GPVF. I did not pick that up. That's all from me so far, Chair. Thank you.
Good morning, Ms. Smudley, Ms. Khan. I'm covered. My colleagues have covered. Thanks.
Thank you.
Thank you, Chair. Sorry, Asia, just a follow-up question with regard to Commissioner Ngumane when he said false sexual offences cases. I want to bring it back to the vetting. When, for example, a matter is taken on appeal and the perpetrators appeal and appeal his conviction, sentence, etc., what happens to this register now where his name or her name is recorded? We speak of expungement 10 years after an offense, etc. Is there any provision that's been made? Okay, thank you. Thanks, Chair.
Thanks. You can go ahead and listen.
Is it okay if I sit? Must I go to the podium?
No.
Okay. Deputy Chair, I'll start with yours. Thank you for the compliments. We really do appreciate it. Just so you know, I didn't sleep last night. I was so stressed. Deputy Chair, regarding getting the names on the register, that is by virtue of an order of court. So the court will make an order that a person who's been convicted for a sexual offense, their name go onto the National Register for Sex Offenders. So I'm going to leave that to the NPA to talk a bit more further about it. All we do as justice is we monitor and we ensure that every name, every order that has been made gets onto the register. And that is done through my office, the courts, and national office. So we have a kind of monitoring mechanism where it's done on a Form 5. Every Form 5 must come to my office for vetting, and then we give the go-ahead to say, all's correct, let it go to the National Registrar. So we serve a monitoring function, but the order is made by a magistrate upon request by the prosecution. So maybe they'll give you more on that. In terms of an appeal, if a person's name is on a register, if an order has been made, then the system is designed such that the registrar at a national office is informed that this matter is pending an appeal. And so it's tagged. So there's a tagging process on it pending the finalization of the appeal. So if they're successful, then their name gets removed. If not, it remains. So but that is done at a national level. The only thing we do at a provincial level is we do the vetting, the clearance certificates to say Asya Khan has made an application, we've checked her against the NRSO, and she's clear. So we do that at a provincial level. In terms of maintenance, sorry?
Speak to it. Okay, I think DC, you also asked us how are we going to get more names onto the register. But our issue here is to clear the names of the people who need a clearance certificate. That's what we do in our region, and those numbers that the chair spoke about. That's a tip of the iceberg. We have quite a backlog. We've been having quite a problem in respect of that because, as Asya mentioned earlier, there are only 2 people who can sign off on that vetting, and that's herself and Mrs. Twala here. So what we have now is that we have begged and pleaded, and for the last 2 years, we have not recruited. So now there's a recruitment process that is starting. So just yesterday or the day before, we heard that we actually are getting 2 more legal admin officers into that component who will then beef up for us the capacity, because it's a 3-step process. Somebody needs to capture, somebody needs to verify the information, and somebody needs to finally approve it. So we are getting some capacity. So as far as the NRSO clearance certificates go, which is our responsibility in the province, we are building some capacity for that.
Thanks. Deputy Chair, and then in terms of getting more names onto the register, as I said to you, that's a court process. It's by virtue of an order. Okay. You asked about maintenance, the link between maintenance, interim protection orders. Deputy Chair, you do know with the amendment to the legislation, if a person is arrested and found to be in a domestic relationship and the victim is domestically related, they can get a final protection order at that initial bail stage, the hearing. And that's a wonderful innovation to the law. So they don't have to come to our domestic violence court. It's done in the criminal court, and they can leave there with a final protection order and all the protection that it offers them. In terms of translating that into a maintenance case, we haven't had many of those where we've heard that someone has tried to get a maintenance order now emanating from maybe this estranged relationship. But we're very fortunate that the link between our family courts is very strong. So if someone does need a maintenance case, then unfortunately they'll have to be referred to the maintenance court, because that's a completely different application in terms of needs and means to support, etc. The test is very different. So, but I personally, I manage the complaints in KZN, and I haven't received a complaint where anyone said that, this hasn't happened. But Deputy, you're welcome if there is something to bring it to my attention. Commissioner, lots of the things you raised relate to the NPA, so I'm not going to try to respond to that. Even the disability and older persons cases, I'm not sure if you were referring to the criminal cases where they are victims. That again, the NPA will be able to talk about that as they monitor those cases. Relationship with civil society in terms of awareness is very, very, very strong. In KZN, I can vouch that we don't work in silos. Unfortunately, there's very little we can do as justice alone. And civil society are our ears and our eyes on the ground. We rely very heavily on them to bring to us what our challenges are, where our problematic areas are, and to join us in our awareness sessions. We actually join a lot of them in their awareness sessions where we take the expertise that are required for their sessions. So we do have a very good relationship. Ms. Muda, I don't know if you want me to touch on the traditional courts, or do you want to? Okay.
Thank you. In respect of the traditional courts, Commissioner, the Act has been passed. The regulations are not ready. When our new Minister Simelane, took over, she said that for us to successfully implement this piece of legislation, it actually needs an interministerial committee to spearhead it and to run it. So in the provinces, we're waiting for that kind of direction. And once the regulations are ready, there is an official that has been identified at national office. Ms. Khan, in fact, only yesterday reached out to that official to say, what are we doing about this training? Because in our region, we're very fortunate. We have 2 chief magistrates who are involved in the training of the traditional leaders on the piece of legislation as well. So, we work hand in hand with them to get this off the ground. And then Advocate Omashni Naidu is here. She's the acting head of the SOCA unit in the NPA, and she's been doing a lot of work with the traditional leaders and empowering the traditional leaders as well. And I think we'll leave it for her to speak to the work that has already been done. So thank you, Commissioner.
We will now hand over to our team. They will almost go to the next level because they are the people who are doing the analysis. Don't be deceived about how nice we were.
Thank you, Chairperson. My question is, the first one is regarding the backlog on the court rolls. The Commission needs this information on the backlog of the court rolls. We specifically requested it so that we understand the status of our cases in our court rolls. So would you please provide that information? And we need you then to explain why are you not in position to provide that information, or why did you not submit it to the Commission? Is there challenges in that regard? I will tell you why. Because once you identify delay or backlog in the court rolls, only that can tell what percentage of cases are further investigations, what percentages of those are specifically DNA outstanding, also the magistrates. Speaking to the question that you were raising about presiding officers, you not being in control of the process. But if you are not providing that information to the Commission to see that 50% of the cases is because of the magistrates, we are not able to move forward. It cannot then be addressed. Hence, that information is important. So please address this aspect that I'm raising to say, is there challenges there? Why did you not submit it? What is the percentage of this magistrate's contribution to this? So that we go to the heart of the problem on the court roles that the issues that we are having. The second aspect also is you mentioned that we should ignore the statistics that you provided to the commission, and that is concerning. Where did you get those statistics? What is wrong about those statistics? Why would you only rely or say we must disregard it after you've provided it and say we must then rely only on the statistics of NPA? Is there a gap between you and NPA? This is concerning because it's affected this cooperation, and we don't know what it means for your meetings that are meant to actually deal with this, and you need to be speaking the same tone with NPA in as far as the statistics are concerned. So please explain, why is this the issue? Why do you have these statistics which may be misleading your office? Further, you raise the issue of judicial officers that you don't have control on. The pillar 3, it's clear that there are roles which DOJ is leading. There are also roles where NPA is leading, so on and so on between the stakeholders. In your meetings, what did you then discuss about this, the issues of the presiding officers? You need to know that, so that if it's affecting your court role that you are responsible for, that you are managing, then you speak about it in those meetings so that these magistrates can be reported. So we need that information to the commission to understand that are the magistrates not coming to the party in this process? Are they also causing issues there? So please indicate to us your relationship there, so that if there are gaps, the commission can assist with appropriate recommendations that are addressing the problem if there is gaps or there's issues with the magistrates in as far as the court roles are concerned. And then the other aspect you raised is regarding the SOS, the court system herein. You have outlined what courts you have identified. Then you mentioned the alternative means, which is Microsoft Teams. There are challenges of network. Other areas are rural areas where these challenges are there. So your evaluation, can you please provide us that report to say what impact does it have? Because then if it cannot reach certain percentages of these courts and it cannot serve the communities, then that alternative means it may not be appropriate. So if you are not providing that guidance to the commission to say, we took this as a result of, after we have seen that there's this gap of shortages of systems or material, SOS system, but given the technological challenges and network challenges, how did you take that into account as well, rural areas and so on? From the court monitoring that was conducted by the commission in 2023, 2024 in the courts, we had that challenges of even reaching the court telephonically. Now, how does this system, how is it effective now in assisting? I'm not rejecting the alternative means, but its efficiency must also show in the reports and evaluations that you are doing, which we need you to speak to. The issue of accessibility to the courts, when did you identify the accessibility challenges? You have identified this court. Is it upon receiving the request of the commission? Please give more information. When did you identify that, so that we can be able to see, were you delaying even in dealing with it or not? When were these challenges identified? It's important to understand so that we see that, have you been responsive, because the pillars do require you to take these means. Yes, they are important, but did you only start identifying these courts only after the communication from the CGE, or have you been knowing about them in the past and maybe you are struggling in ensuring that these courts are compliant and people are, accessibility is improved? Yes, thank you. It's regarding where you said 9 courts were identified in as far as improving accessibility. When was that done? The further aspect is what is the role of the DOJ in as far as the TCCs is concerned? You know, it's comforting that giving experience that you are about to exceed the office. Please provide to the commission what are the challenges there that you have been identifying so that we can speak to it, as the chairperson rightfully said, it as the legacy that you are having. Give us that role. Your presentation, I did not hear your active role in the TCCs. Any challenges or issues there, and what recommendations? We must remember this engagement of the commission is aims at identifying those gaps and then coming up with the recommendations that can assist the system. We acknowledge that everything is not in the hands of the Department of Justice, but we need you to indicate those transparently, to say these are the issues with the TCC system, and hence we are not speaking much about it maybe in the presentation. And similarly, can you please let us know you raise so important questions that look like it's actually gaps that you have been seeing just when you are about to exit regarding teenage pregnancies. You are raising those issues, but what are the solutions to them? Can you go back to those issues and tell us what was not working in the system, so that based on our report of the commission following this engagement, we can reflect that to say, as you have been the accounting officer all along, this is what has never worked, so that we can improve our systems. And further, in terms of legislation development, I'm glad you mentioned your active role in as far as contributing to the legislative development. But these questions I was raising, as if you do not keep records and data of these meetings, how do you effectively contribute to the legislation if you are not giving us that there is this data that shows that something is not working, and then you be able to contribute continuously to the development of the legislation? So I believe even from the engagement you are having with your stakeholders on all the issues that we are dealing with today, those meetings records, we need them so that we see what has been discussed and what is proposed solutions, be it legislation or directives that your meetings on quarterly basis are bringing to the table. Because if we don't look at it at that angle, the previous legislation was in amendment in 2022. It's 2 years down the line. Is there a new that we are seeing from the table, be it from you or with cooperation with other department? You mentioned very important aspect that the cases of teenage gender-based violence against teenagers, the outcomes are not coming out. You've been tracking the outcomes. I mean, that is delay of justice. It means cases are not moving. But what we don't hear in that system that you have a close relationship with, what is not working there in as far as this system is concerned? Thank you, Chair.
Thank you, Chair. My HOD has covered most of the questions, and my commissioners have also covered most of them, but I do have some concerns as well, and questions. When we look at Pillar 3, the monitoring and evaluation framework for Pillar 3, it talks about improving access to survivor support services through a victim-centric criminal justice service that is sensitive to and meets their needs as one of the key interventions. Now, Ms. Moodley, you have stated, as my HOD has also touched on, you have stated that you have no control over what decisions magistrates make, and they have most control over the process. Now, what I would like to know is, what are the steps that you have taken to equip them? Because the monitoring and evaluation framework talks about GPV service delivery training and support, and it includes magistrates. And DOJ and CD is leading when it comes to this. The number of officials trained within the CJS dealing with GPVF matters. We'd like to know the data, the stats on how many magistrates have been trained, or what are the steps you have taken to coordinate, alternatively facilitate the training of magistrates. You are seeing this as a gap. You cannot control outcomes once matters are in court because magistrates have a discretion. The pillar talks about training. So what steps have been taken by DOJ and CD to ensure that the objectives of this pillar are realized when it comes to that? And regarding the recruitment process for intermediaries, the Commission would need more information on that. Would like to know when it started, when it would be finalized, how many new intermediaries are we looking at, all the data, all relevant information regarding the recruitment of intermediaries. If you have already decided where they will be allocated, we would also like to know which courts they are going to be allocated at. And regarding the allocation of the existing intermediaries, we'd also like more data on where these intermediaries are allocated. Yes, that is all for now. Thank you.
Thanks. That is all from us, but as we pointed out, we will be writing these down so that we get formal responses that we will factor into our report. So you can go ahead and answer those that you are able to answer, and just point out those that you may not be able to answer here, and they will be included in part of the package. Thank you. Of questions coming to you.
Thank
Thanks.
you, Chairperson. In respect of our first colleague, the backlog courts, the court rolls, the DPP's office, NPA will answer that. This question number 2, and where we've asked you to please ignore our statistics, let me just say to you that we have a system at the moment where we capture on ICMS. When a report is generated, it's generated on another system called SQL. Even our auditors are having problems with the statistics, because what we will reflect as a case that has been captured in Pinetown Court, when the report is generated at National Office on the SQL system, it will show that it's not generated. So we print screenshots to show that it has been done. So I'm afraid it's an inherent problem with the system. I'm not a technical person. I don't understand it any further than that. And people up there who have better knowledge of systems have been working forever trying to fix all of this. So it's a fact, there's a problem with our systems, and we are saying to you because I swore an oath up there, I'm not standing by the statistics that are submitted here. I'm saying to you, please do not go by those statistics, because it's a problem. We even have to say that to our auditors up front, and agree on what system we're using. And quite frankly, right now, I am using we rely more on our registers. The registers that come in, our manual registers for information.
Yeah, no, I'm sorry to disturb you. The question maybe in its simplest form is, why then did you put those statistics in your report, then you discard them here if you are not confident of them? You should have said statistics, we refer to NPA stats maybe, but not put them in
Yeah,
your
look, at the time, it didn't occur to us. We submitted because we were being pressed for responses on all the questions that were submitted to us. So that's quite frankly the reason. Okay. In respect of the question 3, in respect of the judicial officers, as I said, we do not have control over them. So the two questions I'm going to answer together. The second colleague's question as well in respect of judicial officers and their training and that kind of thing. So they belong to the OCJ. They do not belong to DOJ. We do not train them. They are trained by a unit called Sajai. So if Sajai trains them on certain things, we are very happy and we are very lucky. If they're not trained, they're not trained. However, we do sit with them on platforms called it's the Enhancement and Efficiency Committees that were set up by the former Chief Justice. And we have a regional Enhancement and Efficiency Committee that is sitting on Friday. And that is the platform for the regional courts, that is. So that is the platform where we can raise issues that we have picked up, the DPP's office and ourselves, that we have picked up in respect of magistrates' courts, whatever issues might come up, whether it's a need for training, whatever. Then there is one that is chaired by the JP called the Provincial Enhancement and Efficiency Committee. So in that space as well. So the judiciary submits reports, and I'm not sure whether the CGE wants to, consider a separate consultation with the judiciary, because the judiciary do submit reports. They submit reports on the number of court hours. They submit reports on reasons for postponements of matters and that kind of thing. And that might speak to some of the issues in respect of backlogs as well. So we do have those meetings with them. We do discuss those issues where we find a particular court, these matters are just not moving. What are the reasons? What are the challenges? How can we help? How can we exist? Okay. Then the fourth question on the alternative methods. Remember, I said that the alternative method is used only if a SOS machine is not working on that current day. Because usually once we know that something is not working, it is registered with the technician, and in 2 or 3 days' time, a technician does come out. Sometimes the parts in the machines are so old that it then needs to go to Randburg, Pretoria, Johannesburg for replacement parts to be sent down, and there might be a delay. And if a matter with a vulnerable witness is scheduled in that time, then we use the alternative methods. The alternative teams method is not something that is used every day. It is literally something to help us. It's a stopgap measure. It only helps us in absolute critical urgent needs. You would have heard from Ms. Khan that 9 machines are being bought this year. I think last year we did 5 or 4? 5 machines last year. So we are trying our best to replenish as we're going along. Let me also say that nationally the department has a project where they are going to be replacing all the recording machines with a new system called CRAVS. So it's the Criminal or Recording Audio Visual System. Okay? So, yeah, so between them and CETA and IJS, there's all kinds of talks going on, but the system has been approved and they now need to secure the funding and procure the system. So there is that big plan in place. What we are doing now is really just, dealing with the most urgent and critical issues and our needs on the ground with the available budget that we have. Okay, and then as far as network goes as well, we have reported those issues, and there is a plan to enhance the connectivity. So I know many of our courts have already received fiber to enhance connectivity. There is a report on that. I'm quite happy to share that with you, Chairperson. on exactly which of our courts have received the enhanced connectivity measures that DOJ is putting in place. That is also something that is managed at national level. We do not have the capacity in the region to deal with those kinds of IT issues. Then you've talked about accessibility. I'm going to leave Ms. Khan to answer that question because this is not something that's happening now because the question came from CGE. It's been over the last couple of years that we are dealing with accessibility to the courts. The TCC is the baby of the NPA, and the DPP's office will respond to that. Yeah, so all what I have picked up on gaps in the system and that kind of thing, I have raised it at whatever, like you mentioned, teenage pregnancies. I have raised it at whatever platform I stand on. You know, I'm a gender activist and I'm a children's rights activist, so I reach out and I speak to people about these things. We need a better monitoring in respect of this. As we have heard our colleague now quoting the responsibilities that we have on the NSP in respect of monitoring of matters, we need something child-focused to take care of children. And that's what's missing. So, you know, so please, we're all going to do whatever we can to do that. In respect of legislative development, we don't... Sorry, I'm pausing that. Okay. All we can do is in respect of promoting legislative development is to relate to the internal, relate our concerns to our internal structures. So we have branch meetings within DOJ, and we can make input into the South African Law Reform Commission. So those kinds of things do happen, you know, and unfortunately, I know the SALRC have many projects on their table, and some of them are just not flowing. Like, for instance, if you think about what has happened to the sex discrimination, you know, where's that legislation? I'm not sure. I haven't heard anything in the last year about it. So, so in respect of what is not working, it is our responsibility to point out what is not working, and as I said, we do that. We do have structures where we raise those issues, and you know, we do speak to those things. Asya, you will speak to the recruitment of intermediaries and the accessibility of courts.
Thank you, Chair. Chair, this project of physical accessibility to courts has commenced from 2021. So from that financial year, every year we've been doing a little bit. Unfortunately, we can't get a court to be certified as disability friendly without DPWI coming on board, especially if there's infrastructure changes that are needed. For example, putting a ramp, adjusting a toilet to make it victim disability friendly, etc. So from 2021 to date, if I'm counting the 9 that we have done this year, we've done 35 courts where we've equipped them with all the necessary tools that they need in order to qualify as a disabled court, disability court. So it wasn't from a complaint, it's from a project that DOJ commenced at national office, and it's rolled out every year. It's part of our plan for the department that we have to meet certain targets, and each province is given a target and we meet ours. So that's in terms of that.
Sadi, can I just also say that it's not only accessibility for the public to come to our court, it's also accessibility for our magistrates. So there has to be a courtroom that has a bench that is accessible for a disabled judicial officer.
And then in terms of recruitment, we just want to highlight that the recruitment process is in phases. So there's phase 1, phase 2, etc. And I believe that the posts are approved by DPSA, and they decide which are priority posts to be filled. So it's after very, very many years that legal, even we get into posts. At the moment, there is no recruitment taking place for our permanent intermediaries, but as I said, we are continuously trying to recruit ad hoc. So for now, there are no recruitments for intermediaries. One of the challenges we're experiencing is that there's these projects in justice where someone gets seconded with a legal qualification to another department, for example, to the Family Advocate's Office, to go and gain experience. Now, when that person leaves, we're left with a gap. So for the year or 2 years that they've gone to the family advocate or the state attorney or wherever it is, that gap remains and we can't fill that post. And that's actually one of the intermediary posts where the official was seconded to the family advocate's office. And there's nothing you can do because they're still in that post in essence. So, but we manage, we've got in all our districts, and so they appointed for districts so that they can assist at the various courts. So, Ms. Mundi, I think I've covered.
Thank you, Chairperson.
Thank you. As we said, we will be forwarding the written questions to you. One of the questions that we're going to be forwarding to you is a full report on the IT system that has actually been suggested as being introduced or that has been recently introduced or in the recent past. We just want to know the last ITC upgrade in the Department of Justice. And I'm saying in the Department of Justice, not KwaZulu-Natal, because the duty that is put on the Department of Justice by the Constitution does not speak to provinces. I just find that duty bearers tend to say, I'm not coming there, I'm here. I'm not coming there, I'm here. And yet when it suits them, no, we don't work in silos, so-and-so will come and answer for us. So which one is it? But what is of concern for me with that is that the supposed beneficiaries, the citizens of the country, fall between the cracks. You know, when we say delays in the court are a responsibility of the judiciary, they keep statistics, they should be knowing. It is not good enough. Criminal Procedure Act 51 of 77, 342 cap A actually says the judicial officer investigates, and where there are challenges, they're supposed to submit a report to that effect. And guess where the challenges could be? It could be the prosecutor delaying. It could be the legal representative not coming on board. It could be the infrastructure failing the process. But above all, that infrastructure failing the process and everything else that happens there, NPA or not NPA, DOJ is the final custodian. Section 34, when it says everyone is entitled to a fair hearing in a tribunal of their choice, speaks to DOJ. Then DOJ evolves to set up those different tribunals. One of them would be the NPA. The NPA is not a separate organization from the DOJ. You are an implementing arm, if one could say that, of the DOJ. That is why even your statistics, that is why some of the issues you forwarding them to DOJ, etc. DOJ does not roll out, implement the attainment of justice. It has delegated to you via saying you will prosecute. And in your line of prosecution, make sure that there's a free, fair trial towards justice. So we're not talking about two departments. So I want to emphasize this because we are not going to walk away here, pretending it's two departments. You are not two departments. NPA, you are an prosecuting arm towards attainment of justice, which is the responsibility of the Department of Justice. So I just wanted to clarify that. All right. So we will be asking you that question on the ICT. We will also be asking you the question on children, because children should not be an issue that we are saying here, what about children? SOMA 2013, Sexual Offences and Related Matters Act of 2013, actually addresses the issue of children. It addresses the issues that you raised. Any child, any person with a responsibility towards a child is supposed to report, it's supposed to amplify the challenges that the children face, etc. And then prosecution comes in. Teachers have got a responsibility. Health workers, as you said, have got a responsibility. And over and above, then, when you prosecute as NPA, it says the fact that a child has been violated has got to be an aggravating circumstance. The fact that an agent has been has got to be an aggravated. We should not be looking for a special section on how to prosecute a child. It is there already. And we're making the mistake all the time in South Africa by saying, where is the legislation? Sexual Offences and Related Matters speaks to that. Older Persons Act speaks to that. Domestic Violence Act has been so extended, it includes everybody. Domestic Violence Amendment Act of 2021-22 even talks about spiritual abuse to cover all of those issues of people going to churches, and there's exorcism, there's rape, there's what, in the name of we are removing demons. The country is covered. But above all, chapter 3 of the Constitution talks about interrelations in terms of government. 41(1)H actually talks about how we have a duty. You must remember the Constitution is supreme law. We have a duty to support each other. That is why we are going to be taking some of these things to the relevant portfolio committees. But why I'm raising it now, I'm raising it to say, let us avoid the issue of saying, I'm justice, you're NPA. I'm gender commission, I don't come in. When you raise something about the ITC, I'm supposed to take it forward and say, we had a session with DOJ. ITC is not working. Even auditors are not able to audit correctly. What does it mean, DOJ? Portfolio committee, what are you doing with the fact that you keep receiving reports? Those reports are not a true reflection. You don't say, oh, it's the portfolio committee on justice, because section 181 says we are the institutions as the CGE and others that must ensure that our democracy is strengthened. How democracy is strengthened is protecting each and every citizen. So I just wanted to, explain that we all have a duty. With those few words, I would like once again to thank you. All the work that you are doing, please stay at it, keep at it. We know in our country that we are actually overwhelmed with some of the challenges that we are experiencing. In a normal country, we should not even be having an NSP. In a normal country, we're supposed to be having people idling in court as interpreters. We should not need intermediaries, but we are under siege. That is why all of that infrastructure. That's the sad part of our country. But you are doing what you are doing, and we will be taking some of the other aspects. And I'm challenging you, Pat, to actually take forward some of the issues that you have raised. Legislation is in place. Let's amplify the cause. Okay, thank you very much. Thanks. Bye.
Thank you very much, Chairperson. We are now
You'll
going
raise it,
to get,
Commissioner.
we are towards the end of the first part. I'm requesting Commissioner Ngomane to give us reflections. After him, then we will coordinate how we take a break for tea.
Chair, it's fine. My submission here, hence we are caucusing with the chairperson of the commission. It's that maybe let's do reflections after the NPA session because there is a very thin line. Thanks.
Thank you, Commissioner Ngomane. On that note, I can ask then that we break for tea. Hold on for me. Oh, okay. I am then asking that let us take a 15-minute break for tea and we will regroup after tea. But my HOD is here to also perform another task.
Thank you. Ms. Moodley, thank you. You are released under oath, so you can be free now. Thank you.
Oh, he's gonna pick you up too. Yeah, yeah, yeah. Oh, sure.
Our colleagues, may we ask you to mute while we are on break? Thank you. Thank you, everyone. We are now proceeding to the second part of today's proceedings. We will have National Prosecuting Authority. The process will be started by the presentation from the Acting HOD Legal, Mr. Tsietsi Shuping, followed by the administration of the oath. Then we'll get a presentation by the National Prosecuting Authority, followed by questions and responses, and we'll close with the reflections from the Commission for Gender Equality. Mr. Tsietsi Shuping, we are ready for your presentation, please.
Thank you, Program Director. I'm just waiting for the presentation to be projected. Thank you, Program Director. Before us is the presentation for the National Prosecuting Authorities in this investigative hearing. We have already outlined the Commission's mandate, being that it is an independent statutory body created under Chapter 9 of the Constitution. This hearing is regarding the implementation of the NSP, which was initiated after 2018 following the presidential summit. It aims to address high rates of gender-based violence and femicide in the country. And most importantly, the National Prosecuting Authority is one of the key stakeholders identified by the NSP. Pardon me, I was not moving my slides here. Thank you. It is the National Prosecuting Authority as the key stakeholder. It is identified for the purpose of this investigation and for the purpose of checking compliance and monitoring and evaluation of the implementation of the NSP. So therefore, this presentation will indicate what information, the information that National Prosecuting Authority has provided to the Commission. The focus area, as we know, is justice, safety, and protection. So the key NPA responsibilities are effective prosecution of gender-based violence cases, support survivors with a multidisciplinary approach, and to minimize secondary victimization. With regard to the specialized units, the Commission inquired, is there any further specialized unit at the NPA? It advised that there is a specialized unit in KwaZulu-Natal province dedicated to GBV and sexual offences, and it is currently in operation. It is one sexual offences and community affairs, which is named as SOCA unit. when questions regarding the caseload of gender-based violence matters handled by the SOCA unit over the past 3 financial years, the NPA provided the information which outlines the conviction rate. So in other words, it was not necessarily answering the question regarding the caseload that the NPA is having. When the commission is only provided with the conviction rates, this does not assist the commission as far as understanding the caseload, because what the commission looks into is how are the prosecutors handling these cases in different courts, how are these matters, caseload of each of the prosecutors, and so on. So if NPA can provide specifically that information and not only regarding the conviction rate. And NPA further indicated and explained that SOCA statistics will differ from general national prosecuting services statistics because not all cases are reported at the TCCs. So their stats can be more than what is necessarily reported at the TCCs. Thank you. Regarding the question of whether there are any specific training programs that have been provided to prosecutors, they did list several initiatives that it is provided training on. One of them is the National Soccer Training on GBV, which is part of the NPA's annual training schedule. They also review annually to reflect latest development in legislation and case law. Additionally, training on DNA and cybercrime training hosted by the United Nations on drugs and crimes is being provided. The Commission requested the details of those trainings to be provided, including the content and frequency of those trainings and the number of prosecutors trained through those programs, and the NPA stated there's the training schedules and content in this regard. That information will be submitted to the Commission during the hearing. So this is also a question to NPA. Why was this information not readily available? Is the information regarding this gathering and compilation of this data? It is important for the timely submission of information to the Commission and through any report. So therefore, if from the request of the Commission, it's taken NPA for more than a month until now not to be able to provide the data that is being required here in regarding these programs to the Commission, then that question must be answered. Is it because there's an inefficiency or inadequacy in the systems that can generate these reports quickly so that responses can be up to date and time bound? And then regarding the performance data, this is the information that the NPA provided regarding the SOCA unit. In the year 2021-2022, there were about 7,411 matters that are reported, and the conviction rate there is 66.5%. In the year 2022-2023, matters reported were 7,332. Conviction rate was 69.5%. And the financial year 2023-2024, matters reported were about 8,000. And the conviction rate was 7.4%. And it's reported that the conviction rate has slightly improved in the 2023-2024 financial year because the target for conviction rate is 70%. Now the issue regarding these statistics that are provided that comes to question is when 7,411 cases are reported, is the conviction rate on 7,411 cases. So that is a problem. So NPA needs to break that down so that the commission understands out of the 7,000 cases, how many were on the court rolls, and conviction rate must then at least speak to those matters. So in essence, when conviction rate is only reported at 66%, that can be 20 cases. So we do not want to assume that there were 20 cases and conviction rate is 100% because it's 20 cases. So NPA must be clear so that the system can track these cases. 7,000, how many is actually reached the court? And then how many did they not reach the court? And so that we can also find out of these 7,000 cases, what happened to them. Is about 400 the one that's seen the light in the courts, and what about the remaining 7,000? This question assists in checking also the relationship between NPA and SAPS. So we need information here from NPA to clarify now in terms of the instructions that are issued by NPA, the instructions on dockets. Are they retaining from the courts? And is this contributing to the statistics on the court roll delays? So please, we look forward for that presentation so that we do not only report on the conviction rate, which may paint a beautiful picture that there is performance. However, thousands and thousands of cases are not seen in the courts. In respect of the TCCs, the Commission requested NPA to provide the staff component of each of the TCCs in the KwaZulu-Natal province. It indicated that it has 9 TCCs spread over the province or in the 6 district municipalities. Whilst each TCC has state advocate, the site coordinator and victim assistants designated for each centers. Josini and Edendale do not have state advocate, and Mdendeni does not have a TCC site coordinator. And there is also a concern from the commission regarding the lack of a TCC in Zululand. So basically that means that with Zululand having as been one of the districts that is leading or having more cases of gender-based violence, what then is the measures there addressing the lack of the TCC in Zululand? So if NPA will then address these issues regarding the TCC in relationship to the sexual offences courts or specialized sexual offences courts, are these TCC related to those sexual offences courts, or they are just been placed there? How are they placed in districts? So that information can assist the commission to understand deeply the information that the NPA provided. And there was also a question regarding whether there are personnel available 24 hours a day on and on weekends. It advised that the NGOs are available to provide services at the TCCs, while the Department of Health and SAPS are on call whenever is necessary or when the cases are being reported. The Commission inquired whether there is personnel received sensitivity training to minimize secondary victimization, and NPA indicated that personnel are trained on social context awareness in GBV, which include gender sensitivity training. And ad hoc training sessions on GBV are also addressed during staff meetings. The Commission further inquired whether there were mechanisms at NPA in place within the TCCs to ensure that the victims receive adequate legal support and are informed of their rights and legal processes, and the answer was in positive, that there are means in place within the TCC to ensure that the victims receive adequate legal support and are also informed about legal processes. What the Commission noted in the response from the NPA, in its explanation, it refers to victims and survivors using binary terms like his or her, which also questioned the issue of inclusivity with the material that the NPA is having. So in their response, it creates then that awareness from NPA or sensitization, perhaps the need for NPA officials also to be trained on inclusivity and not only use binary terms like his or her when speaking about victims and survivors. And further, the NPA policy directives on sexual offenses and domestic violence are currently being amended in line with the legislative development. And noting that the amendments were passed in 2022, domestic violence and sexual offenses, it's then questionable regarding the material if the developments or the material is still under review, then what type of training is being provided? Is it not outdated? What is the turnaround time of providing this training, updating with legislative development? Because if it takes time, just as an example, a period when the NPA provided responses to the CGE and to date, I mean, that it can be huge impact on information that NPA is providing to the community. NPA is responsible for prosecution, so meaning the community may be misled. So it is important for the NPA to highlight to the Commission its turnaround times when it comes to the new legislation. How long does it take them to review that legislation so that training that is being rolled out, be it through NPA material or material of justice, it is aligned with the legislative development so that it does not even mislead even the prosecutors themselves regarding these new developments. The NPA, it has also provincial and site-specific protocols that are reviewed annually and are signed by stakeholders. Thank you. Regarding when NPA was asked regarding whether there is any standard operating procedures and policies in place to ensure uniformity and accountability and oversight in the operations of the TCCs, NPA advised that it conducted the detailed efficiency review of all TCCs nationally. Out of this process is identified a shortcoming in respect of standardized and uniform processes nationally. They advised that the draft SOPs has been developed and will be workshopped with relevant officials during Q4 for implementation in the next financial years. Regarding whether the centers develop protocols with, pardon me, the NPA officials are required to follow NPA policies due to the multidisciplinary nature of the TCC's challenges which arise concerning service level agreements and protocols are addressed in the implementation meetings and are resolved and escalated to provincial oversight committees. And internal oversight is undertaken by internal audit. However, the details of the key findings of these audit and these meetings were not shared with the Commission. And regarding the operation of the TCCs, they do operate 24 hours, 7 days per week. The staffs are available during working hours, and the TCCs that are not operational throughout 24 hours, they report cases through trauma units and hand over files in the next morning. The TCC that are closed, social services is provided through NGOs outside regular TCC working hours. And regarding the security personnel designated to the TCCs, NPA advised that security personnel is provided by the Department of Health, and the Department of Health is responsible for ensuring safety of both the staff and the GBV victims at the TCCs. Regarding the measures put in place to ensure that the victims are not turned away due to jurisdictional boundaries, the response is that the TCCs and Department of Health protocols provide that no victims is turned away regardless of jurisdictional boundaries. Regarding complaints handling, NPA advised that complaints can be submitted via walk-ins, emails, or letters to provincial and national offices. It further advised that walk-in complaints are addressed on site immediately if possible investigated further. Further, it indicated that email complaints are acknowledged and investigated. The average period waiting period is 2 hours as informed by the TCC protocol. And further, the statistical data regarding conviction and survivor feedback are used to measure the impact of the TCCs. The Commission sought clarity regarding the allocation of resources within the NPA to ensure effective prosecution of GBV cases. The NPA responded that the TCC staff established funded through SOCA voted funds. The budget for goods and services are distributed on a needs basis. No, there is no ring fence allocation specifically for GBV prosecutions, and there was a budget reduction due to the government austerity measures. Limited funding poses challenges for sustaining the TCC's infrastructure. Additional funding is received from the criminal asset recovery account and other private sector partners. Renovations, refurbishment, contract appointment, and consumables and established new site is also supported. So what the NPA can provide in this regard is just to give that indication from its observations. Is the TCC's model working? Is there cooperation? Is there parties not coming into the play? So that in the Commission, considering the responses and information, it's able to give those recommendations. So NPA can indicate what is this, how is this model working, and or propose how it can work so that those can be considered. And in respect of the stakeholders, there are MOUs in place. The Mineral Council also, in respect of that, there is some MOUs speaking to establishment of the new TCCs, refurbishing and renovation of existing sites. Also the Vodacom, SPA Group, Ring Peace Foundation, they have MOUs speaking to infrastructure upgrades, material and financial support for the Tutuzela care centers. I think regarding the resources, it's important for NPA to indicate now if there is a lot of reliance on private maybe funding for this model to work. I mean, the TCC model is a requirement, and it means to be part of the improvement of the justice system in efficiency handling of the cases. So we need to see now what is NPA saying about resources that are made available. Should we continue only relying on other stakeholders without any commitment to a budget that is meant to address the issues of the TCCs? The Commission inquired whether NPA has any standardized policy or guidelines for keeping and filing of the dockets and for the dockets and files of the victims. It advised that the TCC on-site protocol provides comprehensive guidelines for filing and maintaining case dockets and victims' files, and that files are kept in lockable cabinets offices with access restricted to site coordinators and released only for court purposes or written requests or court orders. When asked regarding the challenge of the implementation of these policies and how they have been addressed, NPA advised that it has noted increased number of victims accessing TCC services, which has led to insufficient storage space for files, and the fact that there is no prescription for sexual offenses. That means more data needs to be kept and recorded internally. So the NPA can just also indicate now in this TCC model is the provision for storage being addressed through their meetings and so on, or because if the model was established years ago and now there is maybe high turnover of cases, how is the plans being developed now to address this issue so that these important records are not lost, because indeed when those cases have to be in court and the storages are not addressed by the TCC model, we need to know about that so that prosecution is not affected. There is oversight, annual audits by NPA internal auditors. They also ad hoc site inspections conducted by the TCC provincial managers. In conclusion, the Commission has noted issues of coverage in some areas which are densely populated and have no TCCs, whilst the NPA and SOCA unit has made visible efforts in prosecuting GBV cases successfully. There are still significant gaps between the investigation of sexual offences and their ultimate prosecution. The Commission recommends that the prosecution guided investigation be strengthened to ensure that matters that are reported are successfully prosecuted. Thank you, Commissioners and Chairperson. That is the presentation for NPA.
Thank you, HOD. Let me give an opportunity to Chair. Oh, I can correct. Okay, thank you, Chairperson. Acting HOD, I need to call you back to please perform the important task of oath administration so that we can then have NPA to come and present.
Who is the seniorest of them
I'd like to
all?
call on stage Advocate Harrison, please.
Thank you. We will be administering the oath for the purpose of the record. Can you please state your name on the record, please?
Elaine,
All right. Would you like to take an oath or affirmation?
oath.
Thank you. Please repeat after me and say, I, name and surname,
I, Elaine Harrison,
do hereby make oath and state.
do hereby make oath and state.
I know and understand the contents of the declaration I'm about to deliver.
I know and understand the contents of the declaration I'm about to deliver.
I have no objection to taking the prescribed oath.
I have no objection to taking the prescribed oath.
I consider the prescribed oath to be binding on my conscience.
I consider the prescribed oath to be binding on my conscience.
Please raise your right hand and say, I swear that the contents of this declaration are true,
I swear that the contents of this declaration are true,
so help me God.
so help me God.
Thank you, Chairperson. The deponent is truly sworn.
Thank you, Chair. Chairperson and Commissioners, before we continue, I just wish to introduce the colleagues that I'm with here today. I have got Advocate Dlamini. She's a Chief Prosecutor in the province. I then have got Advocate Naidu. She is the Acting Deputy Director heading the Sexual Offences section, which is the soccer unit in KwaZulu-Natal. Then I've got Advocate Rusi, and he is also part of the soccer unit in KwaZulu-Natal. I thought, Chairperson, so that there's an understanding, because I've requested the colleagues to come and do presentations so that the Chairperson understands and there's no confusion. When one looked at the questions that were sent in, it was regards to a specialized unit. And the specialized unit is the soccer unit that deals with it. But when you look at it, we've also got cases that are being dealt with. When the case comes in, it may go through the TCC, which is the Tutuzela Case Center, or it may go directly from the police station straight to court, which will then end up with the chief prosecutors. So there are two different systems, and it does become confusing if one does not understand how it is actually done. But with the specialized unit, they will deal with all it's in regards to the Tutuzela care centers. But when we look at it as a whole, the statistics that we keep in the general section also speak to the number of those cases that are coming from the Tutuzela care centers. And hence the reason why I said Advocate Lamini be here. She delivers the presentation on our actual court statistics, because it also encompasses the statistics of the Tutuzela care centers. So I think it was the questions that came in that made it a bit difficult, but I guess this is the first commission. I'm from the time I've been here as the Director of Public Prosecutions, this is the first time we've attended such a session. It's a learning process. Next time when you do come around, we will then be able to actually know what you want. And that is why there's a bit of maybe information that has also not been provided to the commission. So, but that is why we felt that for the purposes of your investigations and the accounting session, let us bring everyone together. So we've got the general prosecutions, then we've got the specialized. All of them both deal with the sexual offenses cases. Yes, so that is why I've got all of them here. And as I said, it's a learning curve, and next time we will be much better prepared with regards to the responses and just separate them for the commission so that you understand. Having said, the daily court return sheets are then gathered, collated, and are compiled into a daily sheet, becomes a weekly, becomes a monthly. It does become cumbersome, but because we want to ensure that we've got the correct statistics, unfortunately, we've got to go through the process. And as much as we are litigants, we retain it because we've got to measure our performance. The daily court return sheet, we can make that available to the commission so that you have sight of what it looks like, because it also has different focus areas on the daily court return, and one of them is sexual offenses and rape cases and so forth. So with these here, we then retain, and this is what Advocate Lamini will be presenting to you, is those statistics which we gather from our daily court return sheets, which we then submit to our national office, and which we also use at any platform where we are required to provide statistics. Platform such as this which we are at today.
When you say national office, you mean DOJ?
No.
You mean NPA?
NPA National Office. We don't provide the Department of Justice with statistics. We will share our statistics with them when we are called upon. If they say, please can you assist us with these statistics, please can you, but ideally we do not share with them because we believe that they are the custodians. But because we've got a working relationship with them, we do share the statistics that we have with them. Our statistics go to our national office in Pretoria. So, or the office of the national director. That is where our statistics go to. And as I said, there are problems with our electronic systems. So in KwaZulu-Natal, Chairperson, we rely on our manual counts. I'm not saying it doesn't come with challenges. It may come with challenges, but we believe it is the best way to retain the statistics. Chairperson, there was also a question from Mr. Shuping, the HOD, so that for the purposes that when the presentations are done again, there will be a proper understanding. When it comes to the issue of court performance and dealing with how are the courts performing on a daily basis and looking at it as a month, in each and every province, there's structures called case flow management meetings. These are chaired by the judiciary. At those meetings, what ideally should be happening is that this is where you discuss the court performance. In other words, that is where you look at the court hours for each court within the area in which you're in. You will look at the number of cases finalized. You will look at the number of backlog cases. And then we as the NPA will come in and say, out of these number of cases that's outstanding, Chairperson, at that particular forum, we're finding that we've got so many sexual offenses, and of that, so many of them are backlog matters. This is so that everyone can understand, because this is also our focus or priority area that we look into each and every single month. Unfortunately, I am under oath, and I am going to say this so that, and I will stand by it until the end. In KwaZulu-Natal, Chairperson, I have a bit of a challenge with regards to the regional courts cases. And in the regional courts, this is where we're dealing mainly with our really serious cases, our murders, our rape cases, so mostly our GPV matters and any other serious matter, because ultimately at the end of the day, we determine in which forum a matter goes into. The regional courts, and I'm saying this, Chairperson, because it's important that there's an understanding by the Commission. In the regional courts, they deal with all the serious matters. So all these courts will have sexual offense matters in their murders, robberies, all of them will be in these courts. And we have raised the concern about the output, meaning the total number of finalized cases in the regional courts. And it has caused a bit of a stir in KwaZulu-Natal. Unfortunately, it has. And it all arose as a result of an email that I had forwarded, where I was just suggesting that maybe some courts which I had looked at were finalizing nil cases in a month, 1 case in a month, 2 cases in a month. And this is that is where I was coming from, to say we need to look at the output of the courts, in the regional courts. Unfortunately, there has a bit of a stir that it has caused, and the issue has been brought to the Provincial Enhancement Committee. This is where the JP sits, and we believe that this is where we'll be able to be resolved. I am not going to take an oath in office and not indicate the true picture. There are courts, these courts are hybrid in KwaZulu-Natal. Our sexual offense cases are falling within those courts, and there are courts that sometimes do not finalize any matter in a month. Sometimes they finalize 1 case, sometimes they finalize 2 cases. If you're looking at an output like that, and then you look at the actual court hours, the optimal utilization of the court time, these are the issues that we believe that these structures should be deliberating on, determining what are the challenges, trying to put into place interventions, and then monitoring our output going forward. We have never ever intended to put a target for any court to say each court must finalize so many cases. That was never the stance we were taking as NPA. Ours is because of the very nature of having our sexual offense matters or our GPV matters. We are saying, let us look at the output of these cases. So on that note, Chairperson, Advocate Dlamini will give you the numbers, total numbers of what we've got totally of the regional court, break it down to say, of that number, this is the sexual offense number that we've got, and then she'll also give you the total number of backlogs, and then what of the total backlogs, what is the total of the sexual offenses. So that is how we've put it, so that there's an understanding of where we are. But there's a lot that is going on in KwaZulu-Natal, and we are hopeful that with the intervention by the JP, we are going to see some better results and probably get us all to sit together and discuss our court performance. So having said that, Chairperson, I'm requesting that Advocate Dlamini take the stand. Thank you.
Good afternoon, Chairperson, the commissioners, the colleagues, and everyone. Chairperson, can I just start with a few things in response to the questions that were raised before? The first one is the number of the regional courts in the province. I know that DOJ have requested the Commission to disregard the numbers that they've given. the numbers that we have, it's 73. And I have a breakdown of those. I'm not sure if you want those breakdown. Yeah, you can. Yes. Oh, okay. 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 The province is divided into, for operational purposes, the province is divided into 6 operational regions that we refer to as the clusters. And each cluster is headed by a chief public prosecutor. And these clusters are aligned to the district municipalities.
Okay.
So then you'll have Durban as one cluster, Pietermaritzburg, Empangeni, South KZN, North KZN, and the Intuzuma cluster. So there are various offices that fall under those clusters. So the breakdown of these regional courts are as follows. Durban has 15, but 2 of those, for purposes of the discussion for today, are specialized commercial crime cases. Specialized commercial crime court. So maybe we can remove those from the equation. Therefore, we'll be left with 71 courts. Pietermaritzburg has 9, Empangeni has 16 due to the geographical position of that cluster, mostly rural courts. Then we have the South KZN, which is a Port Shepstone cluster, which has 9. Then we have Northern KZN, which has 10. Then we have the Intuzuma cluster that has 14. That totals 71, excluding the specialized commercial crime court. We also have 2 high court sittings, one in Pietermaritzburg and the other one in Durban. There are also circuit courts that sit if and when there is a need to do so. There are 8 sexual offences courts. The rest of the courts, Chairperson, will be hybrid courts. They are hybrid because they will deal with any other offenses and sexual offenses. What I've taken here is only the regional courts, because my understanding was that though it is GBV we're talking about, but most focus is on the sexual offenses, which is part of the GBV. If the information that I have is insufficient, we can then look at the district court and provide that. So you have your hybrid courts, because they deal with sexual offenses and everything else. You also have the regional court civil jurisdiction now, where you have the normal regional courts also dealing with the civil court matters that also take time away from the criminal matters. The second thing I wanted to talk about is it was recommended that the PGI must be strengthened. I'm not sure if my colleague will deal with this, but because I'm here, I'll just deal with it briefly. PGI is what we live by. On the issue, we live by. This is what we do on a daily basis, and this is our focus area. On the issue of the cases that are enrolled versus the cases that are in court, I will provide the statistics, but that statistics will not deal with the cases that are reported and the case versus the cases that are enrolled. The statistics will talk about the cases that are in court and the cases that were finalized for a specific financial year. But as a province, we have identified that there is a gap because we have a lot of cases that are reported with the police, but we have very less cases that are in the courts. So we then look at the system to try and establish why is there a problem. Because if we cannot account for those cases and even know what is happening, then our presence here is of no value really. So at the directive of the DPP, we then created 2 systems. One we call a local structure, which is the terms of reference applicable in the local structure. This local structure, we sit there as the NPS, which is Prosecution General, SOCA, who is leading in that structure, and the police. It is in that structure that we are looking at how many cases were enrolled, what happened to them, how many do we have in court, and what happened to those courts. But as time goes on, we realize that we're not really being effective because we do not have a monitoring and evaluation system. We then created a provincial structure which is chaired by an outside stakeholder, which is Community Safety and Liaison. They are sitting today as we hear. The purpose of that structure was to look at the local structures that I've mentioned. Are they doing what they are supposed to do? What are the problems that are arising from the local structure that have not been resolved, and therefore they're escalated to the provincial structure? But it also allowed that level of accountability because it is chaired by the external stakeholder. We sit there and we dissect and we look at that. And part of what we came up with was to address exactly what was raised, the gaps in between. So we decided that on the non-arrest cases, this means that a docket was opened but no one was arrested. As prosecution, we need to see that docket within 14 days of it being open so that we can then start to provide the PGI, which is prosecutor-guided investigation. Then we will give the pen date so that the docket can come back for us to see how far we're going with this matter and so on. So this is what we have put in place to deal exactly with what has been raised by the HOD. We started that last year. It is working. There are teething problems. We're dealing with them as we go along. But at least we have a system that we thought it's going to work. Then I'll go to the actual statistics. What's that? Okay, before we go to the convictions, the conviction rate, I just want to deal with one of the issues that was raised, the numbers that we're talking about. In the 2021-22 performance cycle, the regional courts, Chairperson, as I indicated, that I've only focused on the regional court. The regional courts in the province and the High Court, inclusively, we had 5,346, that is not on the slide, 5,346 outstanding roll. That's a general, that's everything that the courts were carrying. 2,789 of those were backlogs. We finalized 709 cases. The conviction rate, we've already indicated it is 70%. Our conviction rate was 70.7. The following year, 2022-2023, the total outstanding roll on the cases that we're carrying at the end of the financial year was 5,719. 2,498 of those were backlogs. We finalized 631 cases, that is the sexual offenses, and our conviction rate was 71.6. The following year, which is 2023-2024, our outstanding roll had increased, not that much, but we've seen that increase. The total outstanding matters in the regional and high court was 6,387, and 2,992 were backlog cases. For that year, we finalized 791 sexual offenses matters. Our conviction rate was 70.9. We've also added, we know you didn't ask for the information for this year, but we've provided this. For us, it was the projections. The information we have is up to Q2. Already, if we're looking at the projections, we can see where we're going. The outstanding roll, as at the end of September, total outstanding roll in those courts was 6,606. 2,897 of those were backlog cases. As
You are aware it's not projecting?
yeah,
Oh, okay. Huh?
Sorry, Chair, they are trying to sort out,
Okay,
yeah.
okay.
It's part of the package.
Okay, you know why? Because I think you're starting at step 2. It would have been nice to see the baseline and then the conviction rates and then the backlog.
yeah.
This story is not starting where it should. That's why I was wondering that maybe you think it's projecting.
Okay, this is 2021, 2022. We have from April up to Q2, maybe we can go to the last one. I don't know if you want to go through each month or you just want to go to the Now, can we go to slide 1? Chairperson, I didn't do that Christmas thing, I promise you. I want simple things. 2021, 2022. Okay. That's the conviction rate.
This one is totally different to this one.
I have no idea what that is.
You know what, if it keeps falling, don't worry. We do, this is the data that we have anyway.
Yes.
That we have said is not sufficient.
Yeah.
Because you're telling us about percentages, not telling us about actuals. And we should put stuff from actual we take it from there. Okay, so we can proceed, Advocate Lamini.
Okay, Chairperson, this is 2020, 23, 24. Okay, no, that's fine. So this is 24. Okay. No, let's go to the content. The years are going to be mixed up here. This is 23, 24. The conviction rate as we close our book we're at 70.9, but going back to what we've raised, Chairperson, 23, 24, we finalized a total of 791, be it guilty or not guilty, inclusively. And conviction rate is 70.9. And the total outstanding roll, this is everything that the courts are carrying, was 6387 with a backlog of 2,999. In the other slide, there is the outstanding roll for the sexual offenses only. So I think the technology is letting us down here, because then that would have allowed you to marry both, to see the total outstanding roll, which is the sexual offenses plus everything that the courts are carrying. Then you zoom into the outstanding roll for the sexual offenses. So this is up to now, which is the information that you did not request, but we had the information, so. The outstanding roll for the sexual offenses that is in the regional court and the high court, which is the trial courts, is 2,215. It's important, Chairperson, linking with what the DPP had said, and 795 are backlogs. Yeah. Okay, this is the first quarter of 24-25. This is really throwing me off the track, really, because the information is so mixed up.
Please just take your time, go back to where you want to guide us. We have read the report. We do have some of the questions. Don't stress. These things do happen. This is the nature of technology. Don't worry too much. Just go back to where you want to start. And if you might, sorry. Just go back. Okay, yeah. Just go back to where you want to start. If you don't want to use the slides, let's switch it off. We have read. We will be asking questions. I don't want to stress you. Yeah.
Chairperson, I think my focus was to demonstrate the workload that is carried by both the regional and the high courts for everything. But then to demonstrate how much of the sexual offenses have we dealt with, how much we have finalized, and what is equality prosecution out of that, which would be measured in terms of the convictions. And also to give you the numbers linked to that, because the conviction rate on its own, it pretty much does not say much. You can have one case finalized with 100% conviction rate. So I wanted to demonstrate to you the conviction rate, which is quality prosecution, and the number of the clients that have been serviced through that percentage and correlate that. And this is what I've started to talk about, the conviction rate and the number of the cases finalized versus how many in total, everything we're carrying. But this would have then shown the actual number of the sexual offenses matters that we were carrying for that particular year. And that is the statistics that I've given before we went there. So I don't know if there's anything that I need to deal with on the issue of the statistics. Okay, just the last one is we have looked at the NSP Pillar 3, and we have identified where we are, or we've identified our role. We've also identified our role, be it supportive or as part of the collective in the justice system. As you correctly pointed out, Chairperson, the cooperative governance is the weight that is driving us. On the few that we've looked into, there are certain activities that we've done as a province to respond directly to that. There might be a lot of things, but there are just few that I can go through with your permission, obviously. There is reduced the backlog of all DNA cases at the lab, especially the sexual offenses. We are a supportive stakeholder on this. The lead is SAPS. But because of this cooperative governance and stakeholder engagement, we have a project that is run by a national office. In the province, it is headed by my colleague, Advocate Naidu. She may talk to it, where we have national office NPA trying to assist us to fast track or to get SAPS to fast track those cases for the DNA. But also as a province, we've also but 3 months ago, initiated a project where we are working with the local lab to see how they can assist us. The second one is the development of phase 3 to 6 on the femicide watch. We are a supportive stakeholder on this, but we are very much mindful of our responsibility on the development in the femicide space. Whatever cases that we have, we monitor them, they are screened by the senior prosecutors. So we acknowledge and we understand our role in this part. The third one is to reduce the levels of violence against children. What we do is we prioritize the child matters, especially when the children are in custody. We monitor these and we prioritize them within our space, because as Ms. Mutla has indicated, what happens in court, the magistrate is in charge of the court. But we do make applications because we understand our role in prioritizing these cases. So we understand our role in this aspect. Then we have the reduced violence against women, or to adopt the victim-centric services. Here we have the TCC has all that we need for the victim-centric services, but also in the court environment, we have a component called the court preparation officers. They are so important because they are the first face for us to meet with the victims, speak to them, and tell them about the court system, prepare them we find that other people are afraid to testify just because they feel too intimidated about the court system. But we have them to assist us. They also give the prosecutors the feedback if, for example, the witness has a problem, witness is sick, or witness is taking medication. So that allows us to render a more victim-centric services. But I was also reminded of a victim-friendly space in the Durban court that was finalized just recently, where the prosecution took the lead, because these are our clients and we understand what they are going through, and we want to make sure that they are as comfortable as they can whilst they are in our environment. And the more they are comfortable, the best we can get out of them from the evidence perspective. The virtual courts is also very important for us because it allows the witnesses to testify wherever they are. And we have seen the court staff making themselves available after hours to sit as a court, to accommodate the witnesses, especially where there is a different time zones. Staff has made themselves available to deal with those cases, to take the evidence of those people. There was a question on the follow-up on cases withdrawn. Once a case is withdrawn in court, it doesn't mean that it is closed. A case will be withdrawn because of various reasons. It could be because the docket is not in court, or the witnesses are not in court, or the accused person is deceased. So there are various reasons why a matter will be withdrawn. It will also be withdrawn where, as time goes on, we realize that we have a problem on the evidential issues, so we withdraw. But unless if the decision is to decline to prosecute because there is no prospects of moving forward, we'll then guide the investigation for the police to deal with the issues that we want, and they return it back to us. We then evaluate and see. So a case that is withdrawn, it is not thrown in the dustbin from our perspective. It goes back for the police to deal with the issues that we have raised. The witness protection for GBV cases, I think my colleague Advocate Naidu may talk to this, but NPA has a subcomponent called the witness protection. We do not have the protection that is specific for the GBV cases, but we explain this to the witnesses, the availability of the witness protection. It comes with complex issues in that you may have to be relocated from where you are. So sometimes it's not easy for the witnesses to accept it. But we offer it, we explain it, and we explain it over and over again. I think that is all, unless if there's something else that the chairperson would like me to deal with.
No, I think some of the things will come out of our questions.
Okay.
Miss Naidu, are you going to do something? Are you presenting? Yes. Okay, all right.
Good afternoon, Commissioner. Good afternoon, Deputy Commissioner. Good afternoon, colleagues. So I liked starting off with a quote, just in line with the Commission for Gender Equality. Gender equality is more than a goal itself. It is a precondition for meeting the challenge of reducing poverty, promoting sustainable development, and building good governance. I think that's an important starting point as we go through further in terms of our presentation. So when we started looking at addressing GBV, especially with regards to the NPA, the Sexual Offences and Community Affairs Unit was established as a result of a presidential proclamation. Government realized that sexual and gender-based violence had been increasing drastically over the years and had to respond to gender-based violence and now femicide in a multidisciplinary manner. And in that regard, our unit, the Sexual Offences and Community Affairs Unit, was established in 1999. With that being created, the mandate was quite clear. The mandate spoke to sexual offences, child justice, trafficking in persons, maintenance, as well as domestic violence. Of recent, we've added the component of community prosecution, and I'll speak to that as I go along. And all of these areas talk to gender-based violence and femicide holistically. When we look at the flagship of the NPA is the Tutuzela Care Center. And I want to take you through the model of the Tutuzela Care Center. Commissioner, you might have heard this before, but you haven't heard it from KZN. So I'm going to go through that model with you. So I think we often speak, and the HOD has spoken about gender sensitivity. HOD, I want to give you the assurance that when we look at the binary terms, that is adequately catered for at our Tutuzelas. How so? Because staff have been trained that when I walk in as a he, as a she, as a me, as a they, as a there, that I am acknowledged as I am. When I walk in, you are not judging me. When I walk in, I'm met by a TCC manager. She's not telling me I know how you feel, because she doesn't know how I feel. But she addresses me, how can I help you? And then she says, and she will never tell you, like I said, I know how you feel, because she's never been, or he, or they, have never been in your shoes. The process will be explained to me. You know, when you go into a place that is unfamiliar to you, you are anxious, maybe sometimes angry, and you do get survivors that are angry. I actually want to use a term. 2 weeks ago, a survivor had come to me and said, I have been a victim of GBV for years. I am a GBV activist, but yet I too am still a victim. But I've changed that name, and this is the word she gave me. I am a victor. And I liked that terminology because she's victorious in her fight and in her stance. But I want to take you back. In the Tutuzela Care Center, the TCC manager will explain to the survivor, the victor, that you are now going to have your medicals done, from my bloods to my pressure to my sugar. But I'm explaining that to you so that you understand, that you're not anxious. Imagine when we decided, or when we were called upon to testify, it was, what's going to happen? I told my colleague, I set my hair this morning and it doesn't look like it's set. But it is unfortunately the situation, as much as you might, it's the subpoena. But in saying that, that is the position that many people go through. Nobody asks to be raped. And yet, when they go into the Tutuzela Care Center, they don't know how the system's going to unfold. They don't know if that person that's greeting me at the door is passing judgment on the clothes that I wear, or if I'm intoxicated. And in saying that, the site manager will now take the survivor through the system. So I already know that my bloods and my pressure are going to be taken. I know once that's done, the doctor's going to see me. But I'm also told it's an invasive process. Psychologically, I'm preparing my mind for it. So when the doctor tells me to open my legs, I know that what the doctor is going to do. Once that's done, I'm told I can have a shower because the doctor needed to do a buccal of my mouth so he could get DNA. In addition to that, the doctor needed to take away my clothes. And in taking away my clothes, I'm also given a set of new clothes from the TCC. You know, I haven't eaten. I was told during a public awareness event that I mustn't eat until I'm examined, and I didn't eat. But at the Tutuzela, I'm given something to eat. But I'm not alone. I'm only 7 years old. I come with my parent, my guardian, my caregiver. And they too are hungry because they too have come from far. So they too are given something to eat. But right now I'm tired. I don't want to give you my statement. I'm listening to you. I'm not forcing you. I have a time to adhere to. I have other victims to see to. I'm not doing that. Remember, I didn't ask to be raped. Once I'm settled, there is police officials in the Tutuzela Care Center that's waiting to take down my statement in my language, in the manner that I am speaking. But in addition to that, once I'm done, I'm now calm, and I now go through a psychosocial process. You've often heard this. I needed to go to the DSD office. I needed to go to the Lifeline office. I needed to go to Childline. But I need to go to so many places, but it's difficult because I can only get 1 day out of work, or I can't miss school. But all these services are now under one roof. Let's make this a little bit more different. I don't want to open a case. Why can't you hear me? And yes, you do get cases like that. And in those cases, you're not forced unless you're a child, because then that's our mandate. Legislation tells us we have to report. And I'll speak to that just now. But I am an adult, and I tell you all I need are ARVs. I don't need anything else. Can you just give me my ARVs and let me leave? But it doesn't stop there. You have somebody called a victim assistant officer. The victim assistant officer is employed by the NPA. Ma'am, can I take down your details? Yes, sure, you can take down my details. The victim assistant officer will contact the victim a month later. I'm just checking up. Have you gone for your follow-ups, your psychosocial? Because today I'm angry, but maybe tomorrow I'm not. And that conversation happens for 3 months. Yes, we've lost the DNA, but I still have a victim. Remember, the legislation talks about delayed reporting, and it cannot be held against me. All of this is important. What's also important about a victim assistant officer, how often have you heard, hey, my matter went to court, nobody believed you, and the matter was withdrawn. But it wasn't withdrawn. He was granted bail. That's what he was granted. Nobody told the complainant that he had bail conditions, and the bail conditions was that he wasn't supposed to be 500 meters away from her. But that's the job of the victim assistant officer. She calls, ma'am, today your matter was in court, and the accused was granted bail of 500 rand. The condition is that he's not supposed to be within 500 meters from you. As soon as he's in violation of his bail condition. That communication is so important. Why? But how does the victim assistant officer get this? Commissioner, you're going to ask me what's the difference between a TCC and a crisis center. Simple. A court link. Why? Because a state advocate is employed by the NPA that is linked to the court. And one of the questions was the courts that are linked to TCCs. Yes, they are. Like in Intuzuma, you have Intuzuma Court. Phoenix TCC, the closest TCC to Phoenix TCC is Intuzuma Court. Intuzuma State Advocate is not only looking at cases in Intuzuma Court, but also Verulam Court, because that's all the cases that go to Phoenix TCC. In this province, Commissioner, colleagues, you have 9 Tutuzela care centers. HOD, I agree. If we can have TCCs in every area, then we would be in a very good situation. Unfortunately, in setting up Tutuzela care centers, you've got to look at police statistics as well as health statistics. And that determines where the Tutuzelas would be established. Why? Because you're not only employing a case manager or a state advocate, you are employing a victim assistant officer and a TCC manager. So there are 3 posts that are created. And these posts are not only within the structure of NPA, it's a multidisciplinary approach. Now, in saying that, colleagues, I want to harp on a victim-centric approach. Put your victim first. And I'll say it again. None of us have ever asked to be victims of GBV. With our Special Director of Public Prosecution, Everett Karigambu, we have moved away from our TCCs being only sexual offenses to it being gender-based violence, which means domestic violence cases also go to our TCC. Now, I want to talk to that a little bit more. Advocate Kusi heads domestic violence in the province. Training of personnel on domestic violence is a priority. With the assistance of Ms. Khan, and my colleagues from DOJ had spoken earlier around how we work together. Commissioner has also spoken about how important it is for us to be on the same page. Ms. Khan has also trained TCC officials in filling in of protection orders. That's important. That's another accolade for this province. But I'll talk about accolades further. Let's talk about court-directed. And again, I want to skip all of this because we spoke about the multidisciplinary approach, HOD. We cannot, and you'll see in this particular province, and I'll sing our accolades, we are different. We're different to the other provinces, and I stand proudly and I say so. We have strong, very strong stakeholder cooperation. Why? And I'll say this, it's that domino effect. One falls, we all fall. The structures that are in place for accountability, Advocate Lamini spoke about terms of reference. Brilliant. Why? Because the cases didn't correlate between matters reported at stations versus matters at court. So now let's hold each other accountable. And that's what we do. So let's look at what works well. I want to talk to you about, and we'll speak about all of this, but I want to go here because let's zoom in. Advocate Lamini has spoken to you about prosecutor-guided investigation. Vital. Why is it vital? DNA plays an exceptionally vital role in prosecution of cases. But sometimes you don't get DNA within that 72 hours because people report late. But it is guiding the investigation with a fine-tooth comb that allows for successes. But again, we'll talk about DNA. I want to talk to you about here. Let's talk. Ms. Khan has spoken about the Sexual Offences Register. We spoke about legislation and the amendment of legislation. I wanted to start the presentation with this, but now I'm reminded. South Africa boasts one of the best pieces of legislation when it comes to sexual offences. We've covered all of this. We've covered vulnerable persons. We took into account that our students at universities are being raped, are victims of domestic violence. And legislators took that into account. Guess what? Legislators took into account the fact that we have older persons and they are vulnerable. We hear it time and time again how children leave their older parents in residential facilities and don't go back and take care of them. We know of how older persons are being physically and sexually abused. But legislators took that into account. Now, I also want to sing the praises. We spoke about delayed reporting. But Commissioner, when we spoke about the CPA is there to protect us. Section 153, matters held in camera. We make those applications. Why? Because victims come first. 158, again, I as a victim, not a child, I as a victim of GBV, I cannot face the perpetrator. Listen to me. I don't need an intermediary. I just need to be in a separate space. Listen to me. I testify in a separate room. 170 capital A. Ms. Khan has spoken to that. But again, let's talk about the physical, psychological harm. Let's talk about older persons, because they weren't included in 170A previously, 170 capital A previously. Court preparation officers, Advocate Lamini has spoken to that. I want to sing the praises of KZN, a serial rape project. We've heard it time and time and time again. How many matters do we have for serial rape? Over and over again. What's happening to them? Modus is the same. Those cases are escalating. So what have we done? A project that had started at a national level and rolled out to all of the provinces. And here in KZN we have a unit in SAPS called the SECI unit, Serial Electronic Crime Investigation Unit. We work closely with them. Why? Because these cases are brought to us. The DPP has set up a provincial forum that meets every 2 months to discuss these cases, the top 10. What about that top 10 cases? Have those victims been through a Tutuzela care center? What is the status of the accused? What is the status of the DNA? Where are we in terms of psychosocial intervention? Where are we in terms of investigation? These matters are dealt with on a case-by-case basis at these meetings, the top 10 for each month. But does it mean the top 10 for the previous month are not dealt with? And I know you'll ask this question, HOD. How are those cases dealt with? A pending system. Because you don't forget the cases that were the previous month and the month before that. You have to have a sense of accountability. The pending system allows you to follow up on those cases and provide feedback in terms of the status of where those cases are within the criminal justice system. Your next one, and Advocate Lamini has spoken to it, DNA priority. Sadly, Commissioner, we don't have a DNA lab in KZN. If we're looking at the cases reported just at Tutuzela care centers, you're looking at over 60% being children. Let's take this one step further. If you're looking at older persons and persons that are vulnerable, you are looking at people that are unable to testify, but you have DNA. But when we start prolonging DNA, then you lose interest in cases. And my appeal, Commissioner, my desperate plea is, can we have a DNA lab in KZN? Can we prioritize that? Let's go on to this. Ms. Khan and Ms. Mudli have spoken about the child pregnancy project. We don't want to come back here next year and ask the question, what have we done about child pregnancy? Also a pet project of the DPP and the Special Director, Advocate Karigamwa. Why? And the National Director of Public Prosecution. Every year in January, we hear the statistics about how many children are having babies. I will disclose here, Dr. Palandwa from the Department of Health will tell you, a child as young as 9, I will reiterate it, 9, has had a termination of pregnancy. Where have we gone wrong? So again, when we're looking at child pregnancy, what are we doing about it? So let me explain a project that we have. And this project is an NPA-driven project relating to child pregnancy. We've used 2 sites, Edendale Tutuzela Care Center and Phoenix Tutuzela Care Center. The project and the plan of the project is this. Matters that are reported at Edendale Hospital and Phoenix Mahatma Gandhi, you're looking at number of cases of children that have, number 1, gone through for a TOP, termination of pregnancy. Number 2, that have had childbirth. Number 3, that have STIs. Number 4, your sexual offenses cases. We've asked Department of Health to break those statistics into under 12 and 12 and over. If we can have those cases, that will allow us to now start PGIing these cases. All of those cases under 12 should be prosecuted. So that's why the name is not about teenage pregnancy, it's child pregnancy. Because a child under the age of 12 cannot consent. Then the next one is, once you have those cases reported, We now need to monitor those cases in terms of court cases. And that's where your state advocate comes on board. But, and I will say it here, and we're going to seek your guidance. So Office of the Premier has come on board now, as of last week, Friday, when we've convened a meeting to look at child pregnancy holistically and look at the gaps. One of those gaps is that when children go into a hospital to have a TOP, we know the obligation to report, but are we reporting? That's a major gap. And if we don't report at that stage, then those cases fall under the cracks. And we're not getting to those cases. Are we running out of time? I'm almost done. I'm almost done. The other one is to look at educators that commit crimes against children and sexual offenses, and there's a forum that deals with that. Docket screening is another. So we make sure that dockets taken to court have prima facie cases. Something that was raised was traditional leadership. Absolutely essential. With UNODC, we have launched a quick reference guide to dealing with gender-based violence and femicide. That booklet helps traditional leaders on how to identify GBV cases and manage them. What else have we done? We've trained traditional leaders in Mkuze, in Jozini, as well as Ishawe. What else have we done? We've also had dialogues with the wives of traditional leaders. In addition to that, a future project with UNODC is to have a code of conduct for traditional courts and how these courts should be managed. Another is a further project just in terms of engagement in the community and getting people to talk. In addition to that, community prosecution is touching the need in terms of what is the problem in the community. Maybe in this particular area it's domestic violence. In addition to that, Commissioner, we have lots of good practices in South Africa. Eswatini has benchmarked in KZN on child justice. They will return from the 23rd of January for a week, where again we'll go through the system in terms of traditional courts, in terms of our own court system, and do mock trials and visit shelters. So the holistic avenue will be taken. And that's just my quote as we end. But thank you for the opportunity. And if there's anything further that you'd like us, one moment, sorry, Commissioner. Commissioner, one of the questions that were raised was the issue of directives. Those directives, NPA has done directives for sexual offenses as well as DV. Those are complete or completed. The process would mean that it would have to go to the National Director of Public Prosecutions and then approved by the Minister before it's actually published. So it's at that stage right now. So I think, but in terms of the amended legislation, etc., like I've mentioned in the report, the legislation, the manuals have been amended in accordance with the amendments. In addition to that, we spoke about filings in terms of dockets. Dockets are not kept at the TCC. The only things that are kept at the TCC are TCC files, but these are under lock and key. And when the TCC becomes too full of these dockets, we have an arrangement with the DPP office to keep those extra files, again, under lock and key. So no evidentiary value, no dockets are kept, nor are crime kits kept by the state advocates or the TCCs. They are supposed to be collected by SAPS. Just in terms of, my colleague has mentioned, just in terms of Zululand TCC, like I've mentioned before, it relates to the statistics in terms of SAPS as well as DOH statistics in determining where the next TCC would come up. Thank you. Thank you.
Thank you very much, colleagues from NPA. We are, in terms of our program, supposed to be doing Q&A, but we have a pressing challenge with the hotel in terms of their restaurant management. They are requesting that if we may please come for lunch because they have to close the restaurant at about quarter to 2 to start preparing for for dinner. So please accept my apologies that I'm going to ask you to please let's go for lunch, and we'll have our Q&A and reflections after lunch. Lunch was not in terms of our time allocation, because we did not provide for this eventuality that we go for lunch and then come back. May I please propose that we take about, is it 30 minutes enough? Yeah, if we may just have 30 minutes and come back. Quarter past, and this room will be locked? Yes, so you can leave your laptops and any other thing.
Thank you, Advocate Harrison Zungu. Please be reminded you are still under oath.
Oh, yes. Yes, yes. Thank you, colleagues. We are ready to start our questions and responses session. Before we do that, I know during lunchtime, maybe some of us have taken calls on their cell phones. So let me remind you to please make sure that your phone is on silent as we proceed. Thank you, Chair. I'll hand over to you.
Thank you. Ladies and gentlemen, it's lunchtime, it's graveyard shift, so we will try as much as possible to keep everybody awake. Thank you, ma'am, and your team for the presentation. We really do appreciate it. In the sense that, you know, you are here, you tried as much as possible to respond to our questions, but as I said, we are not going to be fighting with each other, but we are going to be honest with each other. Your presentation thus far in response to our questions was underwhelming, in the sense that up to now, I don't know if any one of us is wiser in any way about what you do. Advocate Lamini, you know, you started off, no, I don't think it's you, I think it's your colleague who kept on saying, understand, understand. Let me just brag a bit and say, I'm one of the original teams of people who set up the TCCs. I'm Team Togo Majokweni, Team P.S. Smith, Team Virginia, Team, whatever, I was there. I was there when Liborde was being launched. I was there when Tabiseng Tutuzela and Soweto was being launched. I was there when Weinberg Court was being launched. So you're looking at a veteran here. You're looking at a veteran. So I understand thoroughly. Anyway, so far with the bragging, Naidu just now is going to be accusing me on which side I am, because I always say this, it says, Chair, which side are you on? So we do understand what the whole ethos was about. We even do understand, I was part of those who reviewed the J88 so that it is more user-friendly, etc. We understand that this was supposed to be a one-stop center that enables victims and survivors and their families to get as much support as it is. And that is why I could relate to your presentation, because that was the textbook presentation. That's the presentation that we workshopped. The reality is different. I'll give you a scenario of the reality. The scenario of the reality is somebody rocks up at a Tutuzela Care Center, and when they get to a Tutuzela Care Center, they get told that unfortunately there's one doctor and he's busy at OPD. And they will come. And 3 hours later, the doctor may not have come, but the doctor will come ultimately. And it's one of the few doctors who are willing to work at the TCCs in between their normal work. The rest refuse. They so refuse that at some point, the government recruited Cuban doctors to come and work. TCCs at some point was actually capacitated with Cuban doctors. They all came running, and the first opportunity they got to get a passport out, they went to New Zealand and Australia. The last one that left that I worked with at Ntabiseng Tutuzela Care Center in Baragwanath was at Dr. Martinez. He came and saw patients and said, I'm going for lunch, and never came back. First stop, New Zealand or Australia. So that's the real picture. The other situation is the same person who, as you were saying, Ms. Pillay, will get food. That food is donated by SPA or somebody. It is not food that the TCCs or NPA actually has in their budget. So that food may not be real food or may not be uniform in all the places. Having said that, then you find that there's also challenges in some Tutuzela Care Centers where there isn't toilet paper. Toilet paper when people go to the bathroom. I know when we were doing our monitoring, I went to some of them whilst I was still at soccer. And we were fighting with the nurses, how is it that there is no tissue? And they said, we are sick and tired of taking out our money to buy toilet roll, because the procurement cycle is so long and cumbersome and convoluted that you end up taking out from your money and buying. So that's the real Tutuzela that we know, that has shifted from the textbook Tutuzela. Then you have the situation where maybe there's a tissue or there's no need for a tissue, but there is no doctor. You are now in the Free State in Lijweli Putswa, which is Welcome, Virginia, Kronstadt area. And you get told, we don't have doctors here, we've got forensic nurses. But guess what? There's 2 or 3 of them. They have to go to Virginia, then tomorrow they're going to Kronstadt, and then, because tomorrow is Friday, please go home, don't wash, come back on Monday. Come back on Monday, because only on Monday will they be here in Velkom. I'm now just giving the real horror story, not the textbook story. Sorry about that. And then you get told by a male police officer, we will drop you off at home, maybe you're with your mother, we'll drop you off at home, but please remember, do not wash. But whilst you are still at it, even when you go to the bathroom, please be careful how you sit. This is a male police officer showing you how you should or should not sit in the toilet so that you preserve evidence. But again, depending on where you're at, let's say you are in Nongoma or somewhere in KwaZulu-Natal where there's only one TCC, it's a rural area, etc. And maybe by sheer luck, the specimens are collected out of your body. The truth of the matter is those specimens in that rape kit may actually end up going to the laboratory after days or even weeks. What is the quality of the evidence that we purport to have collected from this person? That we have said, we have examined you, yes, maybe it's the same day, you were lucky, there's a rape kit, again, you were lucky because we know even those were running short, but you got it. But hey, we don't know when we are going to take it to the next laboratory. I don't know which laboratory you are using, but I know Free State uses Pretoria. But the sad thing, just like you're talking about the district, the 60th, they also have the same thing. So in the Free State, the one trip goes to the one region to collect. The following week to the one region, after a few days to another region, and then finally week 4 or week 5, they take them to Pretoria and have to wait until at least the trip to Pretoria becomes worthwhile. This has resulted in a situation where even the guns that have been taken for forensic, people are told, go back home and sit and stay until we come back to you. We don't have evidence that that was your gun or not your gun because it's taking forever. So the case gets lost. So I was just trying to say, yes, I understand the textbook picture. That's where it ends. In the textbook, the reality is different. But that young person who came that we're talking about came through a very huge, intimidating building, which in most cases is a hospital. I even know why it was a hospital. We were running around when Minister Manto Chabalala was Deputy of Justice under Dula Omar, trying to identify those hospitals. They have to go through that maze of the hospital to go to the back of the hospital where the Tutuzela is. And we understand why it is there, confidentiality, this, that. But some Tutuzelas, like the ones that we visited in the Free State again, it's just a place where maybe it's an old ward or a office block or whatever. You just walk in, there's no security, there's nothing. So the rosy picture is not the real picture. It's the textbook picture. I grant you that. And why I want us to get to a place where we can agree is, as I said to the Department of Justice, we as a C9 have got access to Parliament. We need to go there and give them a real picture. We need to tell them that you cannot, every time a forensic nurse retires, you do not replace. We need to go to the Department of Higher Education and say, expedite the accreditation of forensic nursing training. That's the reality and the truth that we want to hear here, so that we go there and become useful to you. We need to go back and say, you cannot have two nurses who at any one time, because of security measures, always have to work together and go to Virginia, as I said, Welkom, Kroonstad, and all of those in one car. It cannot be. But if you come here with a rosy picture, you are not helping yourselves. We understand the conditions under which you work. I would rather we sing the same tune where we say we have difficulties rather than to say all is well. It is not well. We do know that. And I'm appealing to you in your answers to acknowledge that not all is well. Commissioner Naidu here did some oversight in some of the Tutuzela care centers. Yes, you do have a model Tutuzela care center in this province. I grant you that. But not everything is rosy. There is an area, they call it KwaZulu. Zanele? Zululand. Yeah, where there's no Tutuzela. And it's the most rural. It's upsetting that you did not say that. There's no Tutuzela in the most rural area in KwaZulu-Natal. And then we walk away from here thinking all is well. But let me tell you about the young girls who are suffering in KwaZulu-Natal. There are some young girls who are in the home, their fathers are raping them. And as their fathers are raping them, the mothers and sister and aunt and everybody, but magahlale khona la ihlazo lasekhaya. We don't want cops. So that young girl who comes and gets snacks and what is few and far between. The real one is at home. Gutwa magahlale khona la ihlazo lasekhaya. That young girl, the trauma does not end there. That young girl then bears a child. The child of that child is also in that home unregistered and may never get to school. May never even start school because the grandmother stroke something says, ihlazo lasekhaya. Home Affairs does not know about that child. We cannot then sit here and say, the hospitals, when somebody comes to bear a child when they're a child, they come to us, we attend to that. No, that child may not have gone to hospital. That child may have gone to hospital and gone back, and the family says, no, you don't come near us. That's what we would rather hear. And lastly, I just want to say, that picture that was given there, I think why it is so problematic to a point that even you, the people who presented it to us, cannot use it because you know that it is a skewed picture. When you say 74% is resolved, when you are the NPA, I want you to say, of the 74%, 5% only, hooray, were appealed and the judgments were turned down. Were overturned. They were lessened. We are disappointed, but hey, it's only 5%. It then reduces it to only 52 out of 10,000 or whatever, something to that effect. Then we also expect you to come back and say, we are concerned. Of the 10,000 that get withdrawn, that get reported, there's 2,000 that get withdrawn by families, and therefore there's got to be intervention from the side of the communities, the churches, and everywhere else. Political parties, you name it, anybody who works in the community has got to be mobilized to be able to intervene that cases must not be cancelled. But also to actually say the parole board is very helpful, that turning down parole applications. Oh, the parole board is failing us, because at the end of the day, they are dealing with parole as a right when it is supposed to be a what? A privilege. Yeah, Zadele always reminds me that parole is a privilege. We are at a situation where people on the day of sentence have worked in criminal courts. They are the ones who console their mothers when they get 11 years to say, ma, ungakali, ma, 4 years, ngiyabuya, ma, ungakali. We're supposed to be worried about that. Not actually giving a picture, 76% convictions. When after 11-year conviction, after 4 years, that person is back in the street causing havoc. When the parole system has got nothing to do with rehabilitation in our correctional services centers. We know there is no rehabilitation. The overcrowding is such that it does not allow for rehabilitation. And you are supposed to be here and say, we are seeing a rotating door. The same offenders are coming in and out, coming in and out. That's the analysis we would appreciate. Not to say 100% conviction. We've got 36% of re-offenders. Where is that here? And by re-offenders, I'm talking sexual re-offenders. 36%, that's high. We did not see it. So that report has not helped us. That is why I was saying it was so underwhelming. We would have loved to have that analysis from you guys. With austerity measures, we are all on our back foot in terms of finances. So nobody must go to anybody else and say, my picture is rosy. Let's all have a concerted effort. This is not good enough. What I'm getting is not good enough. I'm not giving the impact that I should be giving, rather than actually say the picture is rosy. Section 7.2 of the Constitution, I will always go back there. It says the state must ensure that it protects, promotes, and respects the Bill of Rights. The Bill of Rights, Section 35, actually confirms the right to a fair trial, the right to justice, the right to all sorts of things. But having said that, Section 12 talks about a safe society, right to a safe society. If we continue to give these glossy pictures, we are saying, yes, we're on top of Section 12. Yes, we are on top of Section 5. Everybody's human dignity is intact. We are cancelling out that young girl who gets shown by a male police officer. Go home, come back on Monday, but please, over the weekend, sit like this. Whose dignity is just being eroded just like that in front of their eyes. So I know I've gone this way and the other way, but I was just saying, no. The South Africa that you presented there is not the real South Africa. You are failing us. And by us, I'm talking as somebody who's on your side. I want to go to Parliament and fight your battle. Thank you. Over to you. Oh,
Thank you, Chairperson. Thank you for your presentation, but I have to say to you, having 4 lawyers on that side dressed in black and white is very intimidating on this side, even though I'm a lawyer. But be that as it may, Advocate Naidu, the picture of roses and chocolates that you have painted is not what it is. Before my appointment as Deputy Chairperson, and currently I'm the deployed Commissioner to the province, I spent part of the last 20 months conducting oversights of Tutuzela centers and courts in the provinces. And It is not what is painted. Let me name a few of the centers that I've been to the Mahatma Gandhi Center, and on arrival at this center, no provision is made for the disability. There's no parking that's visible, number one. We got in there, we met a fabulous doctor, he's doing brilliant work. However, his resources are limited. I was accompanied by my legal officer. Unfortunately, she has, bless her, she's very fidgety. We noted that the lamp that does the examination for victims was not working. This is a critical resource in completing the J88. Okay? You speak of rape kits for minors, rape kits for adults. There was no rape kits for minors at this center. The files that is supposed to be under lock and key was in a room where the lock was not very functional. And the J88 is a fundamental document in corroborating the evidence of a victim. And if that document is not under lock and key, then what are we saying? That the trauma we've just put the victim through is not going to be helpful to her case. So for me, it is not what it is. I want to go further and speak to you about the Matadeni Tutuzela Center in Newcastle. On my inspection, it was just a temporary structure. We asked to meet with the doctor. My provincial manager and I went on a journey. That journey found us in a room. In that room, there was files on the desk. I don't know where the files were supposed to be. But the doctor expressed to us his challenges. I don't know if that center is up and running now, but please, when we do write to you, I would like some feedback. Then we have the opening of the Intuzuma Tutuzela Center. I don't know if that has opened yet, but that center was supposed to be opened, if memory serves me correct, Zanele, 1st of November? I stand to be corrected. And that is supposed to ease the burden of the Mahatma Gandhi Center. When is that center opening? You, according to the Department of Justice, you all are the Tutuzela Center is your baby. So this particular Tutuzela centers in these provinces, they are supposed to give effect to your requirements in terms of Pillar 3. And as you heard from my chairperson, we are failing the people of KwaZulu-Natal, and invariably the people of this country, because I shudder to think what's happening in the other provinces, okay? I want to go through a few things, and I would like you to comment on it, if not here today, but when we receive your report or your feedback. You speak about the DNA backlog. Chair mentioned that you all don't have a DNA testing center here. What is your project with the local lab? Who is the local lab, number one? How are our cases monitored? How many of those cases are dismissed because of the lack of evidence? And when I speak of evidence, I'm speaking to the critical J88. Your court preparation officer, what qualifications do they possess? Who are they? Victim assistant officer. Is your victim assistant officer and your court prep officer one in the same individual? No. If not, please further clarity on that. Where is your DNA testing currently done at in terms of the labs that are provided for testing in this country? I'm not referring to your project that you're undergoing. And I just want to speak a little bit about legislation. I agree with you, we do have legislation. We do have beautiful legislation. But enforcing that legislation and making sure that legislation does not discriminate on any person in this country is a challenge we as legal officers face on a daily basis in a courtroom. So I am not adequately convinced that the amendments made to current legislation adequately addresses the needs of all genders. Because sometimes you can have a perpetrator that's in court who's later found to be not guilty. And that perpetrator is sitting with a situation, like I mentioned to you. He's enrolled on the National Register and he sits with a conviction or a caseload that he cannot do anything about. That's always referenced on the subsystem. So sometimes, for example, the granting of a final protection order on the first appearance may not always be the right course of action when you look at the other side of the coin. But that is something we as a commission will look at when we're looking at possible making recommendations for legislative amendments. But these are my questions to you. The other issue that I wanted to speak to you about is the Tutuzela care packs at Tutuzela centers. Is this an initiative of the National Prosecuting Authority, or is it provided for by your civil society organizations? I'm going to leave it there for now, but if I have anything, I will come back to it. Thank you, Chair.
Good afternoon. My concern is around resources and budget allocation. In your response, you mentioned, this is concerning, that there's no ring-fenced allocation for prosecution of GBV cases. Now, I'd like to know what is the possible reason or reasons, and does this not in a way contribute to the huge backlogs or impact on prosecutions? Thank you.
Okay, thanks, Chair. Chair, by and large, I'm covered by yourselves, so I won't really be long. But I just want to check a few areas which were not covered in your presentation in respect of the success rate of the soccer unit against the caseload. If you can say, since we've got soccer unit here in the province, this is the impact you have noticed, this is the success, this unit indeed is adding value, or maybe there are areas that you need to improve on. But also I want to check, PT, Department of Justice left. If you've, oh, they're still here. Oh, I saw, okay. Okay, not everyone, yes. In respect of your staff, if there are any staff members in your employment who are also accused of GBVF cases, and CGE report that was tabled here, I don't know if you have a copy, but on page 5 of that report, it says number of sites. Basically, it talks to the sites that gave report in respect of the conviction rates. Number of sites, 2021, 22, 23 years. In fact, financial years. It says number of sites, for an example, under 2021, we had 8, but only 5 reported. In 2022-23, we have 9, only 7 reported. 23-24, we've got 9, only 6 reported. So the question is, why other sites are not reporting? It will be good to know that. Then, Chair, my request is that when the data is provided again, let it be segregated in respect of gender, age, and other sectors of the society, so that we can get a full picture, because now it's just a general picture, and we don't really get to see who's who in that data. Maybe let me stop there, then I will talk on the reflections. Thanks.
Thank you, Kamangomani. Just to come back, I would like to know from you, the staff that is employed at the Tutuzela centers, who are they employed by? Do you have an MOU in place with the Department of Health, the Department of Social Development? The reason I'm asking this question is because I want to make specific reference that those centers that I conducted an oversight at, the doctors were not exclusively for the Tutuzela centers. And that is one of the requirements that is in terms of the pillar. So, yeah, that the TCC has a doctor exclusively designated or a forensic medical practitioner. Thank you, Chair.
Thanks. Before I let HOD take over, I just wanted to ask about if you could give us a breakdown of the reasons for withdrawal of cases. As part of the fuller picture of resolving, what are the reasons, who withdraws, those kinds of things, so that we can actually see how much of SOMA is actually being observed or undermined. So if you can do that, including prosecutorial discretion. Why I say prosecutorial discretion, we have intervened in a matter at the Palm Ridge Court where the prosecutor had decided that by virtue of you having been at a tavern and had a drink, you cannot come and say you were raped. It won't look good. Why don't we leave this on this, without following it up? And we ended up intervening, and the rapist got 18 years. But it was that irregular and unlawful and illegal prosecutorial intervention that somebody was trying to make. And I wonder how much of the prosecutors tend to say, it was dark, you didn't see this person, it's a non-starter. You are a child, you are 10 years, you are confused. Or, you are 12 years and you are not a virgin. It won't look well when it is not their place. So if you can give me all those reasons for withdrawal. And then the last one, I heard you, Advocate Pile, you talk about outputs versus results, or maybe it was you, colleague. Okay, all right. Yeah, output, to say your outputs are at this point. I wish you could also talk about outputs as in solved, or outputs as in we took out of the system. Because 73% success rate or 73% closed cases does not mean resolved, does not mean conviction. Or if it's conviction, break it down to how much of this was real conviction that we would have wanted. Sometimes I know you guys even want life. How much of life do you get? Or how much of satisfaction do you get in terms of your recommendations as prosecution? Thanks.
Thank you, Chair. In as far as the NPA acknowledges that there is no monitoring and evaluation system that is in place or that is effectively responding to these issues, how have you then taken it forward with your stakeholders and the resolutions thereof? Regarding the aspect of the backlog, in acknowledging the challenges you had on the slides, you mentioned that district courts has 384 backlog, regional courts it's 795. What I saw from those slides, what it wouldn't respond to still is what is the delay? That 795, if you go back and provide information to the commission, categorize it further so that we are able to know, is it further investigations, which is therefore could be a result of SAPS doing investigations, category B, which is the certain percentages, 20%. Next category, there's an issue of the lawyers requesting postponements, therefore totally under no one's control. Therefore, this is 50% of the cases, and so on. So that category will assist us so that we identify if there is any stakeholder who is not coming to the party and is contributing to a delay of the cases that are in the court roll. And then, in as far as you have noted the concerns that you raised, that about one case is being finalized in the whole month, have you taken that up further as well? I think we shouldn't neglect the responsibility to engage our stakeholders regarding this aspect. So please let us know your engagements in this regard, so that we also understand if one court case is being finalized the whole month, let us have answers. Why? Is it because there were no cases that were brought on the roll in the first place? Or is it there are a lot of cases on the roll, but are the magistrate not sitting? Are they on leave? So can we answer it in that angle so that we understand the context of the problem? We acknowledge that you highlighted it, but give us context to understand why one case is being resolved, finalized. Is the court sitting every day? The roll is full, the cases are ahead, but unfortunately the judgment, we only managed to get one for the entire month. So we don't want to assume, but you need to be clear so that we know where the challenge is. And in as far as the amendment of the material, why is it taking long to amend your material to align with the developments? I don't think that should be delayed when the new developments are there. And the electronic system issue, you are forced to end up resorting to the manual system. Now, is it not the issue of even the best use of our resources? Do we need that system? Should it be abandoned and resources not be used to procure these systems which are not useful, and rather resort to manual? Those resources could maybe be used elsewhere, so that we are not having systems that are not working for the justice system. So please indicate there that what is needed then. And you are acknowledging even manual has its challenges too, meaning accuracy could be questionable, accuracy of the data, or what are those challenges without us assuming what could be those challenges, so that we know when we go back to the issue we can tell. Do we need improvement of the manual or of the electronic system, or which one must be abandoned so that we use resources effectively? The last aspect is regarding the projects. You presented about 5 projects here. You presented a project on serial rape, DNA, child pregnancy, educators committing GBV. But what I did not hear at all is, from those projects, what were the outcomes? What is not working? With educators, were they prosecuted? Did you get them? Were they prosecuted? What about your project? Is it not moving? Is it finalized or what? It seems it's a good project that you are having, but what you are not giving us or not using the opportunity is to tell us, what are these projects telling you about the status of our GBV in the country? So if you would provide the commission that, you don't have to provide these answers now if you don't have those answers, but please do upon our request, provided information. I needed to give you context to understand why we needed, so that your reports can guide the commission to whether these projects are producing outcomes that shows which stakeholder is not winning, or which issues are not beyond your control, and so on, so that when we even go to Parliament with this report, we are able to inform the Parliament regarding policy consideration and so on, in the gaps that this important project have highlighted. Thank you, Chairperson.
Thank you. So I only have one concern. Advocate Lamini presented on how the NPA continues to engage with SAPS after cases have been withdrawn to address gaps. Now, my concern is that we have had engagements in the past concerning or relating to one case which had been withdrawn after evidence went missing from a court file. The case, after it was withdrawn, years after it was withdrawn, we met with the NPA after being thrown from pillar to post when we were requesting information from various entities. We met with the NPA. And when we met, it was so easy to, for the NPA to say, this one is capable of being reconstructed. The file is capable of being reconstructed. And if there are these engagements, continuous engagements with SAPS or internally within the NPA to address gaps and to follow up on matters that are being withdrawn, then the next question is, what are the accountability measures in place to also monitor that prosecutors, before allowing for matters to be withdrawn, before allowing matters to be withdrawn, what do they do to ensure that they have exhausted all avenues of taking the matter forward, regarding taking the matter forward? And also, in this particular matter, the lapse of time, being in prosecution, you understand what happens when a matter is not addressed timeously. So the lapse of time in this instance had caused evidence or the versions of the complainants to not be consistent with the first or their initial statements. Now, we cannot say that the lapse of time did not impact that. There were many years apart, but what we can, the reasonable deductions we can make from this is that there were delays, the matter could have been addressed sooner, and the risk could have been mitigated, but then it happened. After that, in instances like that, what does the NPA do to hold people accountable? Yes, prosecutors have the discretion. It's given to them in terms of your founding legislation as well, in your handling of matters. But when you sleep at work, what happens? Somebody did not do what they were supposed to do. And that is the reason why the complainants could not testify or could not recall what had happened. So what are the accountability measures in place? Thank you.
Colleagues, I don't know what you want to do. Are there any of the issues you want to respond to now, or you going to so you guide us? If there's a few that you feel can be clarified now, it's okay. We're going to be writing you a very long love letter asking these questions anyway. But there could be a few things that you actually feel, oh, this is a misunderstanding from the side of the CGE, let's clarify. Go ahead.
Chair. Chair, I'm just not quite certain of the question that you asked about outputs. I didn't quite, outputs versus results. You said when one is to talk about the outputs. I couldn't quite get the question on that one, what you had been asking. Maybe if the chair could just, because my issue was on this year, as a result of the courts not optimally sitting the optimal court hours, and our concerns raised by NPA with regards, when I said outputs, it meant the number of cases finalized. That is what I'm talking about. So one of our concerns is that NPA was concerned about the number of cases finalized in some of the courts in KwaZulu-Natal. And as a result thereof, our attempts to address the matter with the regional court president, which obviously, as I indicated, has had some sort of problems. And as a result, which will then answer my further question, I think, by HOD, is that is why we've taken the matter to the, or that is why the matter has been raised at the PEEC. There needs to be an understanding. We've got REEC, which is the Regional Enhancement, Efficiency Enhancement Committee, which is chaired by the Regional Court President. If issues are not resolved there, they are then taken to the PEEC, which is the Provincial Efficiency Enhancement Committee, which is chaired by the JP, Judge President. So that is, we've got that hierarchy, and that is why we are there. It's not like the matter was left. It's first DEEC, District Court, REEC, and then PEEC. So we are at the top structure in regards, and I can safely say we are going to be addressing the matter between the Regional Court President, my office, and the Judge President. So it's not like it's not, I just thought, let me put it so that there's an understanding with regards to our court performances and what we are doing with regards to trying to address the operational challenges. That's yeah.
Thank you, Madam Chair. Your knowledge on the TCCs, I'm blown away. So, you know, when you started speaking about TCCs, you speak from the heart, and that's something that's so important to all of us, and I think that's why we all are here. I actually do want to talk about the TCCs in KZN, but for the one in Umlazi, was based at Prince Mshweni Hospital, I hear you. Going through a hospital is a daunting experience. And Advocate Kari Gamu is looking at having TCCs as standalones. And yes, if we look at, so like I said, only Umlazi is in that situation. Phoenix has its own, and the rest, the 8 others, are standalones. You want honesty? Honesty I'll give you. We're looking at park homes. Commissioner, you have seen park homes. You have seen them having a 5-year lifespan. And with that 5-year lifespan, many of them are beyond that. But there is a flip side to that coin. There is a light at the end of the road. One of the questions that were asked was regarding, are we totally dependent on private sector? Unfortunately, because of austerity measures, to a large extent, yes. But in the process, right now, as we sit here, Advocate Kari Gamu is in the process of having our TCCs legislated. If they legislated, then it becomes our responsibility to maintain. And if that is the case, then yes, indeed, NSP allows us to have public-private partnerships. And it allows for communities, for public-private, public entities to take responsibility. And you're going to hear that later when you have discussions with the Forensic Science Laboratory. We do need help. But in saying that, in KZN specifically, and I hear the Deputy Commissioner because my heart goes out. But again, in KZN, you're going to see, and I would love to take you on a site visit. You're going to see many of these sites, and it's a work in progress. Again, working with stakeholders. I said this at the initial part about the domino effect. Public work needs to come on board, and which they are. Madadeni, stakeholder relationships. Madadeni is a concern, but silver lining. There is a site already with private funding. There's a building that's already established. Next week, Friday, I will visit the site with Department of Health, with Public Works, to have the process in terms of the handover. So the site is there. A new building structure has already been established, and we'll move in. It's almost there. That light is almost visible. Phoenix, TCC, Mahatma Gandhi, and going into Pixley. I just want to share one thing with you. Advocate Karigamu is busy in consideration in how we move over and what that process. Thank you. I want to sing the accolades of Intuzuma to Tuzela. So Advocate Karigamu is now looking at that move to Pixley Hospital. Pixley, it's now, until we move, it'll become a TCC, but right now, as a crisis center that it operates as, has a colposcope. You would remember the days of colposcopes. We sang praises of colposcopes. Could we have colposcopes? This is the first site in KZN that has colposcopes. The doctors already started using colposcopes. You're talking about lighting. The new TCCs are coming with state-of-the-art equipment to allow for, the best evidence in court is visual evidence. And when you start seeing bruises under bruises, your colposcope is doing things like that. The case manager, when we're looking at the issues of statistics at 5 and 8 and why there's a variation, it's because there was no case manager. And the cases reported was because there was no case manager, and that 5 and the 8 and the 9 will talk about those things specifically. But we'll talk about that in our response. Just on the comfort packs, our responsibility, but also you get NGOs that come. So NPA does provide comfort packs, but you get DOH as well, and your NGOs that will come on board. Asked about the MOU. MOU is in existence, a provincial MOU is in existence. MOU and protocol. KZN, again, speak the truth. KZN, where is the problem? Our protocol has been signed as a provincial level by all stakeholders except SAPS. Why? Because SAPS refuses to sign at a provincial level because national hasn't signed. So that holds us a little bit back. So I will give you also a breakdown of all of these cases as we go ahead. But I think, and just on the manuals. So all of the manuals have been updated with the amended legislation. So there's nothing missing in the current manuals. The only part that's outstanding, like I said, was the directives, which are with the National Director of Public Prosecution. And that has to be then signed off by the minister. But as per the amendments, all of that is in the current updated manuals which we train on an annual basis, which we've already started training. Thank you.
Chair, there's just one issue. I think this one was raised also by HOD about the electronic issue. Chair, I think I came out because, as I said, being under oath, I need to indicate our challenges. And Department of Justice had indicated, obviously, their statistics issue. The data that we give, as I indicated, is because of the systems that we have in place as the NPA. But I can assure the chair that the electronic system, the ECMS, we call it the electronic system, is something that the ECMS, it's a matter that our national office is looking into. I'm not talking KwaZulu-Natal here. I'm talking a country issue of the ECMS. It is out there. It has not produced the good results. We are litigants by profession. We should not even be retaining stats. And that's how I started off to say, we should be pressing a button, being linked to the courts and obtain the statistics. But because those are not working well, we retain statistics. It's for our own internal measurement so that we can measure our performance. Chair will realize there is no manual system that can ever be perfect. So, and I say this with due respect because I don't ever want to make it seem like because we're not using the electronic data, our manual system is therefore going to be 100%. There is no department anyway that can tell me that their manual counting system is perfect. We are human. There will be challenges that are experienced, but what we do is that during the year we do go back and we do what do you call it? Verification of our statistics, because at the end of the year we must ensure that the statistics that we provide are in fact correct stats. So there is nothing more we can do, HOD. We're doing our best. And right now that ECMS system is something that our national office is looking into. We are implementing it, stats are coming from there, but we have decided in KwaZulu-Natal, because we don't want to rely on the ECMS, we will do both, ECMS and manual, but we actually rely on our manual system more. And then we go back and we do verifications. There is nothing more. The NPA at national will have to make a decision ultimately about the ECMS. And because I do sit at that platform, it is something that is being looked into. Do we continue with it or do we discontinue with it? It's something that is there. I just thought, let me tell you where we get our data from. Thank you.
Thank you, Chairperson. Just to add on what the DPP is saying, the ECMS is part of the integrated justice system, which is a system which was intended to create that link from the beginning until the end, which then goes back to your question, Chairperson, on do we follow up on the appeals to see if the conviction that we had stood in the High Court. At this stage, we are not able to do so, but the integrated justice system was intended to give that information, because it was intended to assist us from the time the accused person enters the criminal justice system up until he goes to prison, if he does, or goes to High Court and the conviction is set aside. So we do not have that, but the DPP has already spoken about our electronic system. We would actually like to, we've started something in the province where we also want to use the appeals as a training tool, because we want to know what happened to these cases. Did we do something wrong? And as prosecutors, we want to learn from them. So we've started to have this knowledge portal in the province where the High Court, who deals with the appeal, will then send these matters to us. They help us a lot, also as part of training, and just for us to have a look at it and see what is going on, because we also do have the clients coming back to us wanting to know the reasons. So that gap is kind of informally closed, but we're hoping that once the IJS system is up and running, it will fill that gap. On the cases that are withdrawn and the reasons thereof, Chairperson, we do keep that information. The reason why it did not form part of my presentation was because I approached from a narrow perspective, in that I tried to look at what are the questions, what the Commission want, but we do have that information. So we will submit the details. We have it because we interrogate it. It helps us to understand what is happening. We also use it to engage with the other stakeholders. Like I've referred to the engagement that we have in the structure which is chaired by the Community Safety and Liaison. So we raise the issues there with the hope, with the understanding that because they liaise with the communities, this can go out and we can develop programs around that. The parole board and rehabilitation, I'm not going to be able to respond to that. Okay, then there was a question on, okay, together with the withdrawals, we also have the detailed reasons on the acquittals. We keep that, we interrogate it, we use it for our engagement with the other stakeholders, particularly the police. But we also use that in our community engagement. As my colleague Advocate Naido spoke about the community prosecution. So when we go out to the communities, we talk about these things. We have that information as well, so we'll provide it. The withdrawals due to the J88 on the GBV matters, this is not a problem on the sexual offenses, especially those that come through the TCC, because all the services are there. It comes pretty much with everything already there. Where we have a problem on the J88 is on the assault matters, where we battle to get the J88. In some of the matters we proceed without it. But in some of the matters we prefer to have the J88 so that we can make an informed decision whether this is an assault with the intent to do grievous bodily harm or is it attempted murder. So on the sexual offenses, it's not, because in most cases the victim will be taken by the police to the doctor as opposed to the assaults where the victim will approach the hospital on their own. The qualifications of the CPOs, or court preparation officers. When the court preparation service started, they were not required to have any qualifications. But as time progresses, they are now required to have qualifications. They are required to have a degree in social science. But because the ones who were appointed before that requirement, they are still there. So you'll find both those who have a qualification and those who do not. But right now, the minimum requirement is that they must have a degree. There's a question on granting of the protection orders on the first appearance or on the bail state and whether this is sufficient. Chairperson, I'll go back to the issues that you've raised about the reasons for the withdrawal of the cases. When we submit the withdrawal report, you will note that in the GBV-related matters, we have a high rate of withdrawals because the complainants will come and they do not want to proceed with the matter. We have measures that we have put in place to ensure that when the complainant says she does not want to proceed, we exhaust all the avenues, because we also understand there are various dynamics that are involved in these cases within the family, within the communities, and so on. So we are of the view that the protection order at this stage, at the bail stage, it is important because there are cases where we end up withdrawing, where the complainant just does not want to proceed at that stage. So for us, before we do that, before we withdraw that matter, we want to make sure that at least there is a protection order which will serve as a protection for the complainant. But we also explain to them that you may not want to proceed now, but next week you may. Come back to us. We won't say you wasted everybody's time. We understand the dynamics that are involved. So short answer, the granting of the protection order in the bail state, it is important, and it is assisting because it gives that kind of protection. The question relating to the ring fence resources and in relation to the prosecution of the GBV matters, my colleague have indicated that there is no ring-fence budget, simply because the actual prosecution, the taking your gown and going to court, it is not done by SOCA. It is done by the general prosecution. So the budget that is there will be a normal budget, which is the compensation to the employees. We do not have a specific unit that deals with the GBV matters. So everybody will deal with them. That is why when my colleague spoke about training, it includes everybody, because we understand that everybody will deal with them. So there is no ring-fence budget, and that is the reason. There are two areas where I thought maybe we needed some clarity so that we can respond correctly. On the report, that should include the gender and the age. Yeah, okay, so, and I think, Chairperson, it was you who referred to how many life sentences. Is this in relation to the GBV matters, or? Okay, and clarify it there, okay.
We were asking for the actual demographics based on the stats that we got there. It's not giving a picture. The actual demographics of who is who in that situation. Sorry.
Okay.
In that picture that was presented there.
Okay.
My issue would be if we could get the actual stats from baseline level, because, saying 67% resolved, or let's say 70% resolved, it could be 7 out of 10 cases.
Yeah, I get it now.
It could be 10, it could be 700 out of 1,000.
Yeah.
So can we get the actual numbers, because that's the way we will actually see how the land lies out there. But the other thing, whilst we're waiting for Commissioner Ngomane, because he's going to be doing the closing remarks, is actually to say it's a sad day for us in South Africa, in the sense that, as you were saying, 1999 already we were setting these things up. You reminded me, I went back a few years to say it was only 5 years into our democracy, and at that time already we were saying levels of violence against women are too high. And 2018, 19, 20 years later, or whatever, we then had a march of young people. The rest of the others got it halfway through the road. But it was young people saying, enough is enough. We are not safe. It actually is an indictment on how resources have been misused, how things have not been done properly. Because you cannot have 5 years into a democracy, a thriving democracy, where every country in the world was saying, how can we help? But for a few who were saying, you are free now. Everyone else was saying, how can we help? That is how the Dutch came in to help with Thuthuzela care centers. People were like, how much do I sign? Look how we've squandered our opportunities. Look how we've messed up our jewels. Today, children are having children. With all of us in this room are scared to walk the streets, despite millions and millions of resources that have been thrown into one problem. 2019, the president, 10 years later, 1999, 2019 is what? It's 10 or 20? 20. I knew I was saying something wrong. 20 years later, the 5th president in the 6th administration stood up and said, this is a second pandemic, because women had to stand up there and raise their skirts to show scars. No, there is just something too wrong. So I think I'm saying this because we understand the hardships that you are working under. But bottom line is, we tend to too much to reinvent the wheel. I do not understand how we could have started TCCs in 1999. 2018, we say, let's have something else. 2020, it was IRAP with the view of NSP. And now we are at NSP. But TCCs are still in tatters. I'm using figure of speech. You know, I know you guys are working hard, I'm sorry. But I'm just saying, man, maybe we need to lock ourselves somewhere in a room and say, we're not doing something right. You know, we've got a district model. The region with the highest number of sexual offenses and murders and just outright sheer disintegration of community is the OR Tambo district, where the district model was launched. And the president was saying, we're going to make a model out of this. But you also ask yourself, why is it that when we set up Tutuzela care centers, we are not saying we have 284 municipalities. So let's have minimum 284 Tutuzela centers. How far are we? The president not so long ago said we've got 60 or 59. We are targeting to have at least 66, or right now we have 66. How is it that we have 66 since 1999? What is our roadmap to roll them out? So there are a lot of questions that we need to ask ourselves. No, we just working sometimes, you know, without a proper plan. And yeah, so I just wanted to say that, but also to acknowledge that each and every one of us is trying to do something, and we acknowledge that. With those few words, Commissioner Ngomani, we were waiting for you.
Thank you, Chair. We are at the last part of our... All right.
Oh.
All right. Advocate Rosi.
Yeah, thank you, Chair. Good afternoon, everyone. Yeah, when you were doing your opening remarks about your experiences of TCCs and all, you mentioned the forensic nurses, which is a crucial thing that we need at the TCC. We had one in the province. That one retired. Yeah, so we don't have. Yeah, nurses were trained. They went for training as forensic nurses, but they don't want to practice as forensic nurses because that post as a forensic nurse is not classified or categorized as specialist. So they are missing out on OSD. So they don't want to practice at all. So if you can take that up to Department of Health, you'll be helping us as well. Yeah, thank you. Then the other issue which was raised, I think I've got only two issues. The Zululand, that there is no TCC when it's rural. KZN is 80% rural. It's not only the Zululand. If you look at the Mzimkulu, Klopo, Kokstad, there's no TCC there. The nearest, which was at Matatiele, now Matatiele falls within Eastern Cape. So, yes, so there's no TCC at all. So when we look around before we decide on each TCC, we have criteria that we put up. Then there were issues at Mkhanyakote, which is also rural. So when we look at all these three, we said that, okay, let's put it at Mkhanyakote, which is the chosen one. It doesn't have more stats than this one, but the manner of those cases, the manner in which they conducted those, we had a report from the AIDS Foundation at some point in time about social issues, cultural social issues there. The rapes are happening, we know. Those are rapes. But when you compare the rapes, the manner in which they are conducted are other areas as compared that area, they are gruesome. Some of them you find that they rape and kill and rape and have some body parts. And then there was a cultural practice which was in that research, of which we have to take it up and do some interventions. And then we found that it's happening and nobody knows about it. What do they call when the one when you give birth to a child that is developing a teeth. Yes, we engage there. When one gives birth to a child that is developing a teeth, they take it as a curse. Will you give birth to that child? You give birth to that child, you take it home. There will be a family meeting. Then they will kill the child. They will burn the child. And then take ashes, put it in water, and let the mother drink to cleanse herself. Those kind of things that we even look at when we, because how people are backward or I don't know. So DPP was there when we engaged with those people there. And they were reluctant to admit. At the end, they said, yeah, that was happening. You see that it's happening. So I understand. We will put Zululand into, it's in our mind, but we have to make interventions first that we see that they are really, really in terms of a priority. Yeah, I wanted to clarify that part. Yeah, thank you.
Thank you, Chairperson, for the indulgence for our colleagues, NPA. And I'd like to hand over to Commissioner Ngomane for the reflections and closing the session. Thank you.
Thanks. We've got two chairpersons today, chairperson of the session and chairperson of the commission. So when I say thanks, Chair, I'm referring to both of you. Chair, the reflections are covered in three-part reflections. One is general, two is observations or concerns, three is conclusion. Under general, our submission is that the engagements here were professional and cordial, and the issue of subpoena was clarified, so it was not out of being unreasonable, but it's the law. And we also note with appreciation the issue of online cases and ensuring easy access to justice even through engaging people who are outside the country. And we also note with appreciation the post-filing process that has started. And these reflections are covering both entities or departments. And also we note with appreciation the issue of stakeholder relations. However, we made these observations to a certain extent with concerns that your stakeholder engagement does not talk to issues of PPP, public-private partnership. We do not see the role of private sector in this. You spoke about your relationship with civil society and NPOs. It will have been good to also reflect on the PPP aspect. We also note with concern the issue of the change of information. The information can be changed. We appreciate that, maybe out of improvements or new data coming in, but not to discard the information in this platform. we take exception really to that. You will give us information when you come here. You say, no, these stats, someone else will deal with them. We are not custodian of them. We are not confident of them. That is why then we are submitting, Chair and colleagues, that in future, the issues of technology, the CIO needs to be part of this session, your Chief Information Officers, so that they can reflect on issues of technology and data management and the reliability of that data. Also on child interventions, we're saying your pronouncement on child interventions are noted. However, they should not be without a clear plan around the vulnerable people in the society. I think we have spoke a lot about that, the older people, the disabled people. So there should be a clear plan to say this is the plan for child interventions and other vulnerable people in the society. Pillar 3 of the NSP, it would have been good that you reflected on the areas that talks to you and progress to date around the NSP Pillar 3, as you are the champions. And there is a glaring lack of intergovernmental relations in how you do your work daily. You know, if you talk about the Thuthuzela Center and you don't talk about the victim-friendly police stations, it says something, because these two in a way should talk together. I don't know if you have green doors here, but I know in Gauteng they were launched. I don't know if you have them here. If you have them, it would have been good also to create that value chain to Thuthuzela green door victim friendly. And there's also a white door. Oh, that's why you're wearing white shirts. All right. Then again, we observe that you are not big on doing site inspections. Our submissions that there should be more site inspections, so that then when you come to such platforms, you present the reality, not the concept of what Thuthuzela should look like. And more advocacy needs to be done by yourselves. You should advocate for your clients, for your province. If there is no DNA lab in the province, the question is, what are you doing about that to advocate for it? You should be saying we've spoken to Department of Health, to Treasury, we have made applications, the Minister is assisting. There is a hope that by this date we will have our own lab in this province. And the issue of data management, it remains a great concern. We are of the view must treat it as a crisis. Because, you know, when Department of Justice was presenting other matters, they referred them to NPA. Now NPA is presenting and you don't touch on those matters. So which was really a great concern. In conclusion, Chair, we request that in future, in fact, that there should be follow-up engagements in the next financial year to check progress on our deliberations today, and that both entities should be better prepared. They should have had their own engagements, shared notes, so that you come here as one entity, you come here as a team. Then lastly, we will also engage Parliament on these matters that were raised here today. We will table them the report at the portfolio committee, but we'll be lobbying for you. And we also note the issue of forensic nurses. Those are the things we'll be lobbying for, that they should be part of the OSDs. And there should be more TCC in the rural areas. And lastly, we request that there should be a clear, comprehensive plans on integrating the work you are doing with the traditional courts, so that issues of culture, tradition, and stereotypes are attended by yourselves. So these are reflections which are three-part are presented to you. Thank you, Chair.
Chairperson of the Commission, final words, then you can release us.
Colleagues, I think we've had a fruitful day. It may not have been a very comfortable day, but it was a fruitful day. Fruitful in the sense that there is synergy. We are walking away here having almost a similar, clearer picture. And I think it's also a benefit for us as the CGE that you as duty bearers now know that the CGE is actually on the ground, because usually before we come and call anyone, we do our research. So when we meet in the trenches, it's important that we see or we realize that we are on the same side. So these will be continuing. Engagements will be continuing. I just want to close by saying the preamble of the Constitution is a beautiful one. It starts by saying, "We the people of South Africa." It says a lot of things about we the people of South Africa, united in our diversity, etc. But what I want us to take away today is the part that says, we therefore, through freely elected representatives, adopt a constitution so that we improve the quality of life of all citizens and free the potential of each person. So I want us to look at our role not as I'm getting money at the end of the month, I want to be on OSD, but rather to say we have a duty to fulfill just that sentence of freeing a potential of each and every one of us. With those few words, once again, I thank you, but I would have erred in a big way if I don't thank the employers at CGE. Zanele, your team, Bosti, Nomti, everyone. Guys, can you rise up so that people see who are the people, the few but powerful people who put effort behind. Oh, Matota. Others are reluctant. Okay. And then Commissioner Ngomane, DC Naidu, and Commissioner Naidu, it would not have been possible if we were not a team. Let's keep at it. Mika, why didn't you stand up? Hi, Mika. Hi, Mika. Colleagues, thank you very much. Once again, we're on the same side. Thank you.